Thank you. You could do that all the time. And are we live on? Perfect. Okay. Good morning. Please join me for a moment of silence honoring the officers who lost their lives since the last meeting. And that would be Deputy Aubrey Phillips from the Alameda County Sheriff's Office. Thank you. And now, Ms. Nunez, would you please take a roll call?
Good morning. Barcelona.
Here.
Braun.
Here.
Brazil.
Here.
Donelin.
Here.
Doyle. Dudley.
Here.
Ewell. Gordon. Long.
Here.
Marsh. Nieto.
Here.
O'Rourke.
Here.
Ramirez. Thank you.
Thank you. And I'd like to introduce to my left is William Toby Darden, from our Post Legal Counsel, and to my right is Post Executive Director Manny Alvarez. And now it's a time for public comment. This is the time set aside for members of the public to comment on items on the commission agenda. Pursuant to commission policy, the commission chair will manage the public comment period in deference to the commissioner's workload and meeting time constraints. Up to 15 minutes is allotted at the beginning of each commission meeting for public comment on items on the agenda. Based on recent events, more people than usual may want to address the commission. Therefore, if required, we will go longer than 15 minutes, but may limit the period to no more than 1 hour, as we have many topics on the cover on the agenda today. Members of the public who wish to speak are asked to limit their remarks to no more than 5 minutes each. If we have many people who wish to speak on the same topic, I, as the chair, may intervene and will ask that you limit remarks to no more than 1 minute. Pursuant to existing commission policy, the chair may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. Please be advised that the commission cannot take action on items not on the agenda. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. So, do we have anybody you'd like to speak on public comment? Seeing no one, we will move on. At this time, the executive director would like to address the commission. Executive Director Alvarez.
Thank you, Madam Chair, and thank you, commissioners, for affording me the opportunity to speak. Before I start my comments on SB2, I want to also mention that we're missing one former commissioner, Commissioner Lili Bowie. We didn't read her name on roll call because she was promoted to lieutenant last month, so she very, very well deserved, but she can't serve on the commission as a lieutenant in the position that she was filling. So we will recognize her in May, but if many of you are wondering where Commissioner Bowie is, she's doing work as a lieutenant somewhere in the city of Sacramento right now. So we congratulate her. I'd like to just give you a quick update on where we stand with Senate Bill 2 since the last meeting, because I know many of you are getting questions either from some of your constituents, law enforcement agencies, or people in the legislature. So I just thought I'd give you a quick update since the last meeting at the end of February. So in terms of regulations, on March 25th, we released for public comment 21 regulations. Some of them were new, some of them were modified regulations, all to deal with Senate Bill 2. They're currently out for public comment, but we anticipate presenting those to you all in May, at the May meeting on May 25th. We also anticipate, obviously, we've got at least 2 more regulations that we'll be pushing through in the future on serious misconduct and a couple of other things. I want to thank the Office of Administrative Law. They've been fantastic in working with us on those proposed regulations in advance to make sure we're hitting the mark and that there'll be a smooth review process for everybody. So they've been fantastic. They dedicated one person to help us through the process. In terms of hiring, we know there's been some discussion about how we're going to hire all these people if we do get funding come July 1. So at the last meeting, we mentioned that we were going to repurpose 5 existing positions, 5 vacancies to start the process with SB2. I won't get into the nuts and bolts of how that works administratively because you don't want to hear it and it's not a simple discussion to have, but there are 5 positions that were repurposed. One for an attorney position and one for 4 HR positions. Those are all called for in the budget change proposal, but we want to start the process now. We advertised the very first position on March 1st of this year. All of them have been advertised, and we're currently doing the reviews of the applications. Admittedly, we've not had a lot of applications for those positions at this time. I think everybody's having a challenge, I think, with hiring from, whether you see it on the news or law enforcement agencies, it's definitely been a challenge. But I want to also thank the Department of Finance for giving us the concurrence to do this without the BCP ultimately being finalized. So the Department of Finance provided their concurrence for us to do this under a rule that I won't go through. We also talked about technology at the last commission meeting. And as you all know, we started receiving demonstrations of software platforms in the fall. Our colleagues talked about that and mentioned some of the platforms that we looked at in the last commission agenda item, or the agenda item in the last commission meeting. We also started working with the California Department of Technology in December. We had almost weekly meetings or bi-weekly meetings with CDT on how we were going to move forward. And we ultimately submitted a proposal, a procurement and a delegation proposal to them on January 10th. On April 1st, they provided the approval, the delegation approval for us to move forward. And we submitted it out for bid that same day, I believe, on April 1st. As you all may know, if you've seen the bids or the bid proposal or heard our discussion, we're attempting to move forward with a software platform called Mark 43. It is on the state software list for procurement. Many law enforcement agencies, both in the state and county and city departments, are using it. So that's what we're moving forward with for now. We're starting the review process this week, I believe, is when it closed. So we're starting the review process for the bids. I want to thank CDT for their engagement and their help with us early in the process. They were fantastic, and we were pushing and pushing to get this thing through as quickly as possible. So we do appreciate CDT helping us with that. Now I want to transition a little bit to funding, because as you all know, we spoke about the budget change proposal for next fiscal year to staff and get money to implement Senate Bill 2. So we had discussions with the Department of Finance and the governor's office almost every week, if not multiple times per week in the month of February, January, beginning of March. On March 10th, the Department of Finance came up with a proposal, which was a Thursday. I mentioned a Thursday, March 10th, a proposal to move $3.4 million of existing current year money over to a different account, so to speak, or a fund for us so that we could start the procurement of the software and various other things that need to be done for Senate Bill 2. That was done on a Thursday by the Department of Finance in cooperation with the governor's office. And on Monday, Senate Bill 119 was introduced before the Senate and passed by the Senate on March 14th to approve the money going over. So obviously that was a very, very heavy lift for the staff, let alone we really truly appreciate the Department of Finance and the governor's office helping us and having those weekly meetings and just moving this thing along. They did a really, really good job. Lastly, I just want to talk about communication with the field and what we're doing to communicate everything about Senate Bill 2 as we move along. So I sent an email to the commissioners announcing that we're doing online webinars or online information sessions over the course of the next 2 months. We have the first one on April 5th to talk about proof of eligibilities and appointments. We had 500 people, or almost 500 people, participate in that online forum. The next one's scheduled in 2 weeks for a different topic. So we're going to continue those as we move forward for the next 2 months. In the month of May, we're going to start, we're initiating the process for an informational video to the field that we hope to get out in short order, but we will be starting that in May. And then in August, we will transition to regional information presentations. So we will travel to regions. I'll hypothetically, since I see some folks from LA County, we will go to LA County and perhaps over the course of 3 days, hold presentations that people can come to see what SB2 is all about. So we anticipate doing that in August and moving that around the state. And then lastly, just in terms of our staffing, we had added an additional two people to SB2 since the last meeting. So right now we have 9 full-time staff members on the SB2 transition team. They've done a great job, I think. You'll notice that from all the material that we present today and what you heard from me today. They've done a fantastic job. So we really appreciate what they've done. Appreciate the rest of the staff. A lot of them have had to help them with various things, but it's also caused a little bit of there's 9 staff members that are no longer doing their day jobs, and somebody else is having to, do their work or, suck up the other responsibilities. So it's really been an effort by all of Post to make this happen. And I just want to thank all of them. And then lastly, I want to thank the crew behind us in Computer Services Bureau. Aside from pushing all the technology piece that I talked about with CDT, they've been putting together these meetings. It seems like they're up here constantly doing these webinars and such, and it takes a lot of time, and we don't have staff dedicated fully to do that. And then lastly, Katie and Carrie for always putting these meetings together. So thank you, Katie and Carrie, for all the hard work. And I can answer any questions about any of that if you would like, but that's the update as to what we've been doing in the last month or so.
Questions for Manny?
Yeah, I just have a question on the webinars. Are those recorded that the chiefs and the agency heads can go back and look at the ones if they missed it?
They are recorded and we are putting them on our website. We ask for questions in advance and we take questions via the chat and answer them. So they are available to anybody who couldn't see them on that day. Yes. They're on our website. Are they on there now, Jackie? It's already on there now. Yes.
Plus, there are future webinars that will still be happening, and it's all the same content, isn't that correct?
They're different. So for instance, this first one was on proof of eligibility and appointments. Each one of them has a different topic. There's 4 topics.
Thank you, I forgot. Any other questions from Manny on what he had to say? Okay, I think we're about to enter the deep dive here. And I think it's important to get some perspective. So I'm going to put Manny back on again. Manny, give us the 3,000-foot description of this whole decertification process. Where does it begin? What's the middle and what's the end?
So starting on January 1, we will start receiving information from law enforcement departments that are called for in the penal code, primarily 830.1, 0.2, 0.3, various 0.3s. All Post agencies will initiate reporting to Post on allegations, charges, findings, investigations that meet the criteria of Senate Bill 2. We will also have to start taking complaints from the public starting January 1. We will be doing that via our website, which we talked about previously is already, for the most part, that platform is developed. It's mirrored after the Department of Justice's platform for taking complaints from the public. If you'll notice, one of the regulations that was pushed out during public comment on March 25th talks about what we do when we receive a complaint, what our process and our procedures are to follow. And those procedures are essentially that we receive it and we push it out to the law enforcement agency for appropriate action. And, obviously we track all of that stuff. So that will start January 1. Departments will have 10 days to report that information to post via the software platform. Also, starting on January 1, there's various changes to the notice of appointment and termination, the NOAT, which I think now we're going to be calling the NOA. There's various different identifiers on when people separate from law enforcement. So that will change how EDI looks on January 1 for appointments, as primarily for separations. So once we start receiving the information, then we'll start processing it and see if it meets the criteria for decertification. And obviously from there, it'll come to the Accountability Advisory Board first, then to the commission, then to an administrative law judge, and then back to the commission. That, in a nutshell, is the process. Individuals will have to be notified if they're subject to decertification. So we're working through those processes on how they're going to be notified and such. They have the right to a review. If they do not lodge their right to a review, I believe within 30 days, then it's an administrative decertification. So they'll be notified, they have a right to appeal. If they appeal or initiate a review, then that starts the process where it goes to the board, commission, administrative law judge, and back to the commission. There's also some other back end things that we have to worry about in terms of the separations. They're starting on January 1, every separation will require an affidavit of separation. You'll see a regulation, a proposed regulation that's out for public comment on how those will work. But regardless if it's a retirement, a resignation, a termination, a resignation in lieu of, there will have to be an affidavit of separation that we anticipate having to share with any new hiring authority. So that will change that whole NOAT process. Depending on which box is checked, could cause an individual to be temporarily suspended until there's a resolution. If an affidavit of separation comes through that says a person was terminated for something related to SB2 or resigned in lieu of something that could be decertifiable under SB2, they'll automatically go into a temporary suspension and will not be able to work as peace officers until it gets resolved. That's kind of it in a nutshell. I mean, there's a lot
I know
to it.
there's lots, but I was
We
looking
can-
for the 3,000
Yeah.
and you gave it to me. Now I want to talk about the why. We have legislation which has passed, and in discussing what serious, the definition of serious misconduct, there were already, I think it's about 9 categories that's in the legislation. Is that true?
Yes, 9.
So we cannot take anything out. We can't take any words out, anything out of those 9 areas. Is that correct?
That's correct. They're in the penal code, so you can't.
We're
change
good.
them.
We're good. We can change the law, but aside from that, this committee isn't going to be doing that. What we can do is add things to that or clarify things. Is that true?
Correct.
Okay. And in preparing the commission with information from the community, 2 groups have been formed, Group 1 and Group B. Is that what you're calling them?
Correct.
Okay. And so Group 1 and Group B have given some thought to what the definition of serious misconduct would be, right?
Yes.
And we, as a commission, now this morning are going to have 3 things. We're going to have the penal code section. Then we're going to have Group A's thoughts about that penal code section and Group B. And we, as a commission, are supposed to come up with some ideas that will go on to, for lack of a better term, a whiteboard that we'll see in front of us. And those ideas at the end of today will go back to you and your staff, and then you'll formulate statements, and then we will review them and vote on them in May.
That's correct.
Okay. I haven't heard that I've been correct that many times since I've tried a case.
100%.
Okay, so I've got that. So let's go into the why. why do you need this? Why does the community need this meeting at all? If we already have the definition of serious misconduct, in order for the board and ultimately commissioners to make a decision, why does working on the details of this definition help?
Okay. So first off, you don't have to do anything, right? We could just leave them as is.
Right.
All the 9 criteria that are defined in Senate Bill 2. The challenge with them is some of them are overly broad. And that's what the 2 workshops, Workshop A and Workshop B, addressed, is to see if there's some clarity or the narrowing of the scope to give the staff guidance, to give the board guidance, to give the commission guidance, and to give the ALJ guidance as to what really should be an offense that would cause a revocation. If you look at some of them are literally a sentence. Well, what does that sentence mean? What does excessive use of force mean? Physical abuse? What does that mean? Some of them are a little bit more detailed, but they are open to interpretation. And unless we have some kind of direction from the commission and the board has some direction, and then ultimately the voting members of the commission, there's just going to be masses of information. It's like, well, we don't know. We don't know what the commission would want to do with this. So just send it. So we're hoping to get some requirements, some minimum requirements, some desired requirements, some factors to be considered, just to give some narrower scope to what is said in Senate Bill 2.
Okay. And that narrower scope makes sense to me. Toby and I studied in law school the question of what's pornography, and the Supreme Court said, you know it when you see it, okay, which left everybody up to vagueness. So I think the idea is that we are, as a group, going to help in terms of the definitions, tightening them up so that the future commissioners and the board are in a better position to say, oh yeah, this has already been considered. As a matter of fact, it's written there. We're going to go ahead and go forward, versus each time everybody throws up their hands and says, for lack of a better term, what is pornography? So we're going to do that. Carrie, can you put up what it's going to look like for each one? By the way, this is the one and only consent item on our list. So we'll be spending the day doing this, except for the pizza break when the pizza arrives. And for those of you that haven't given Carrie your $11, I'm suggesting 15 or 20 to pay for everything else that the staff has paid for.
Madam Chair, just for informational purposes, as they're getting it up on the screen, each commissioner has that agenda item, the attachment that was published,
Right.
this document in front of them for reference as well.
Okay, so here we are. So the first one is dishonesty, and the definition is in that kind of lavender color. And then you have what Workshop A thought should be augmenting that statement, and you have what Workshop B is thought to do that. Ultimately, we are going to have a discussion, and I'm going to get a sense of the consensus. Sometimes I'll just feel the consensus in the room because I have a pretty good handle on feeling the rooms, this particular room, in terms of where we're going. Other times I might just ask for a show of hands because I'm going to be unsure. But ultimately, what we're going to end up with is on that whiteboard, we're going to have what this group generally feels they want to do in the first case with dishonesty. So who will be taking down the ultimate statements at the whiteboard? Okay, all right. So any questions about how we got here, why we're here, and what we're doing? Awesome. Then let's start with the first one. I won't read it to you because you can all read. So let's take a minute to read the definition of dishonesty, then Workshop A's view, Workshop B's view, and then let's just open the discussion and dig in.
does continue on to the second page if you're looking at the screen.
And all of you are looking up, I'll assume you finished reading. Let me be a little clearer, sorry. The serious misconduct at the very top, the workshop A, workshop B, what's the term you've been using for that?
So at one of the workshops, or at both of the workshops, they wanted to come up with an overarching definition of serious misconduct. And that's what that is. Obviously, that's open to debate and discussion as to whether that language is proper or whether there is an actual need for an overarching definition.
So I'm going to suggest after we finish the process of going through the 9, we come back to the question, do we even need an overarching, what are you calling it?
Overarching definition.
Definition, okay. So let's leave the serious misconduct overarching definition until the end of our process, and let's focus first on the dishonesty. Toby's going to give us words of wisdom first.
I don't know if it's words or wisdom or not, but I think this might help us. So the question as to whether or not we need an overarching definition goes directly to the language of the legislation. The language of the legislation says that post shall develop a definition of serious misconduct, which shall include the following, and then it lays out the 9 specific criteria. So that there are 2 ways that the commission can go. The first is the commission can say serious misconduct is, and then just go directly into the 9. And then with those 9, perhaps we can help clarify or give other parameters of how the commission views those 9. The other possibility is that since the legislature delegated to the commission the ability to define serious misconduct, and it said it must include certain things, the legislature didn't limit the commission. So the question as to whether or not there should be a separate overarching definition of serious misconduct is going back to the language of the legislation. And Post does have the ability to develop an overarching definition, which might give the commission or the board or the division jurisdiction to review certain acts which are potentially disqualifying that should result in certification, but that do not fit within the 9. So I just thought that's something perhaps we could keep in mind as we're going through each of the 9. You'll see as we go through them that based on the language of the legislative language on each of these 9 areas, it's limited. And there may be, for example, with dishonesty, as we talk about that, there may be some instances of dishonesty which are not covered by that the specific legislative language. And the commission can certainly say, well, that's the legislature has said this definition of dishonesty is what applies, and that's all that we're going to have in the regulation. Or the commission could decide that it wants to go broader. So that's the idea. So I apologize for interrupting, but I thought that.
No, thank you for interrupting, and that's very helpful. Let me make sure I understand the difference. So the first one we'll talk about is dishonesty. We'll talk about the small paragraph that's written there, workshop B and workshop A's thoughts about that. And someone could, if someone felt something wasn't included in there, they could do one of 2 things. They could just take a note and say, gee, when we get to the end, we'll think, I'd like to bring up the issue of also adding this to this general discussion.
Yes.
Or they could say, for instance, general dishonesty relating to the reporting, investigation, or prosecution of a crime, and it talks about a law enforcement report. Someone may say, well, I also think it should include any body worn cameras. I'm making this up. So you could either say, let's add body worn cameras to the dishonesty, or let's talk separately with the overarching definition about adding body worn cameras. So you've given us this so we can think about it.
Yes, that's
Okay,
exactly
so we
right.
could either include things in our notes and ultimately perhaps in the definition, or later on, we could just say, let's talk about dishonesty as it relates to a body worn camera, or whatever other theory we have.
Right.
Am I connecting with people? Are you good, Rick? You guys got-
I just have,
Commissioner Brazil.
I have a question for Toby. So we go through this process, we decide in May, we vote, and we accept whatever that is. In the future, if something comes forward that needs a modification to this, one, is that doable?
Yes.
And then two, so a year or two from now, new technology comes out, there could be a 10th added to it.
Yes, that's exactly correct. And Manny, certainly your regulatory team can jump in as well, but we amend regulations all the time.
Right.
And my view is that since this is really completely new territory for posts, I think there's going to be some element of learning as we go. And we're going to have fact instances that are going to come to us, and we're going to see there's a problem with the particular scheme. And so there may be amendments made by the legislature, or staff may come back and say, or the commission may request at a meeting that there be an amendment or modification to add something or subtract something or whatever. So yes, I personally think this is going to be a living, breathing.
Let me comment on the subtracting something and tell me if
Yes.
I'm correct. Only the legislature can change the dishonesty definition
Yes.
that we have. So we can't come back later and take out anything that the legislator has put in. We can go back to the legislature and say, could you take that out? We can take out what we've put in,
Correct.
and we could put in more information.
Correct. That's
Okay.
absolutely right.
Okay, Manny, do you want to say anything about that?
I think you summarized it all properly, but yeah, when the discussions were happening about Senate Bill 2, there was definite discussion about it should be a living, breathing document. What's applicable today may not be applicable, 10 years from now, and you can add, there's 9, you have to keep those 9, but you may have 10 or 11 or 12. So yes, you stated it correctly. I'm sorry,
Thanks,
one of
Rick,
my
for bringing
colleagues.
that up. And Maria is now stepping up.
Thank you. I'm sorry to interrupt. I know that we want to make this a living, breathing document. However, if it's a regulatory piece, it's going to have to go back through the OAL process, which may take a significant amount of time. So that's my only concern about, yes, you can massage this as we go along, but that process is going to be delayed. Thank you.
Please feel free to stay there. Thank you. Is that the same as please stay? Okay, everybody. Any other questions about the procedure? Ruby, you're good?
I'm good.
Manny? Maria? Okay. So dishonesty. Who would like to discuss, who would like to start the discussion about anything they'd like to add to that definition?
Chair Dudley, if I may.
Yes, please. Commissioner Braun. Is your microphone on?
It is.
Great.
I would like to add the term substantive to dishonesty. It needs to have meant something when the person lied about something, and not so much, no, chief, you look great in that suit. Okay, that could be a lie, but does it mean anything? Or if somebody calls in sick and went to a baseball game instead, does that happen? Yes. Should they lose their post certificate over that? That's up to the agency. So I would like to see a word, Kelly and I were talking about, Commissioner Gordon and I were talking about substantive, egregious.
I love that idea, and I think we all do. But one person's substantive is going to be another person's not substantive, is going to be another person's egregious. And I think any help we can give future commissions by really delineating that or bringing it in just a little bit more. Whenever I go to trial in a case, I have to look up whether it's great bodily injury, serious bodily injury, traumatic bodily injury. At least then I can go to the definition of those 3 terms when I'm trying a case. Substantive also is a legal term, but I'm not sure how we want to use it here or if there's anything we can do to give lay people. Not only am I concerned about future commissioners, but I'm concerned about law enforcement officers on the street. Shouldn't they have a better handle on what substantive is? So you're saying, right?
Yes, yes, if you don't mind, I'm sorry,
Please.
folks, I'm going to have a lot
I
of
want you to
input today.
keep jumping
I
in.
apologize. So as a lawyer, I've prosecuted these disciplinary cases against peace officers as well. And, you know, one of the things that as a lawyer trying to prosecute a case against a peace officer is that I have to prove each element of the charged act. So I understand your point, and I think it's a good one. Perhaps if we got to a broader, more overarching definition of dishonesty. So the commission may or may not decide that this is necessary with respect to the specific acts that are targeted here, which is the prosecution, investigation, or the reporting, investigation, or prosecution of a crime. That probably is substantive in and of itself. At least that would be the thought. That's not a comment about that you look nice or the dress looks nice or whatever, or in the investigation of misconduct. So it may be that it's not necessary to have that sort of a limitation on these specific regulatory definitions to the extent that the commission wants to have a separate regulatory definition of this. But again, as a lawyer, as I sit down to prepare a case to go in front of the ALJ, I need to know how do I prove that it's substantive? That's the question. And so before we add regulatory language like that, we just need to think it through so we can give specificity to the prosecutors and to the ALJ, so the ALJ knows, okay, this is or this isn't substantive. So that's the only point I wanted to.
I agree. And I know it's a nebulous word. It was more to the workshop B term of any dishonesty should all small lies lead to big lies. So not, you know, we always say that you lie, you die for a law enforcement career, but we say little lies all day long and you don't lose your job over it. So I just wanted to make that clear for the working law enforcement officers, that they can understand that not everything is going to get you lose your post certificate. And I don't know the right word for it. I just wanted to address that.
And I would just like to add to that.
Please.
So I think, you know, as part of that, I think, and this may go to the overarching, but I think, you know, as part of this legislation, I think the burden of proof is, and Toby, correct me if I'm wrong, clear and convincing, right? Which is also very subjective. But I think adding language that says, you know, that it is willful, and we can show that it's willful in terms of how that dishonesty affected the case. And I don't know the right terminology. That's why we have you, Toby, maybe to help us with that type of language. But I'm with Commissioner Braun on making sure that we don't make this extremely broad and very difficult. I look at it from the point of the community because they want specific expectations. I also look at it as a point of how I, as a police chief, can set clear expectations. I mean, she's right. Like we teach our officers, you lie, you die. But we also know that what an officer sees is not also what a witness sees. And that is not dishonesty. That is a different point of view. The officer based their observations, and we talk about, you know, and these are things that over the last 27 years that I have learned, you know, tunnel vision and different things that happen when you are in that moment that you don't necessarily see all these other things that other people see. So when you write your report, and we always say, if it's not in your report, it doesn't exist. I'm sure, you know, the chair understands that as a prosecutor, right? If it's not in your report, it didn't happen.
Mhm.
But you don't see everything that happens. So a witness may see something different. That doesn't mean that the officer lied. That is their point of view at that moment. So I think it's important that when we're discussing this definition of dishonesty, that we take that into account and that we can set up things that are, you know, there's always going to be some subjectivity to this. But I would caution against You know, if you call it, like her example, you call in sick, we're going to take away your certification. You know, there are these things called mental health days, and you know, it looks different for the newer generation than it does mine. You know, but they probably will live longer than we do as a result of that. So I think there is, I like Commissioner Braun want to make sure that we are putting something substantive in that, that we can show whatever that proof and that intent is of it, and not just make it overly subjective of, you know, well, this witness saw it differently, so that must mean that the officer is dishonest, because that is not necessarily the case. Maybe Toby can help us craft something that addresses that.
It's a very interesting point, and the truth is, for all the law enforcement executives here, you've probably seen IAs where basically there has to be a decision made by the investigator or by the department as to whether or not there was dishonesty. And sometimes there's a finding of dishonesty just because the investigator credited another report over the officer's report. Therefore, the officer's report was determined to be dishonest, or statements were determined to be dishonest. And I understand completely what you're saying, that sometimes it is very subjective. It's a question of how the officer saw something versus how somebody else saw that. So that makes sense. But I guess my question in terms of this thought process, which I completely understand, again, to me, it strikes me that this concern is more of a concern if we go beyond the specific regulatory language. If we're just looking at the specific regulatory language, does the commission think that we still need to try to include this kind of carve out that makes sure that somehow we have to ensure that it's substantive or willful or whatever? Again, important if you're talking about a sick call out or a compliment. I agree. If we're going to make that something that someone can lose their career over, then perhaps the commission wants to ensure that
Would adding such a word as intentional?
Yes, there are lots of words that we could add, but intentionally, again, I'm going to go back all day long to Chief Braun's comment. Someone sees the dress, hates the dress, intentionally decides to say they love the dress because they want to kiss up to the chief. So that was intentional. So that we're not looking at really intentional. But some of the things that one of you said was, I believe it was you, Commissioner, was how the dishonesty affected the case. Now we're talking about something we can put our hand around a little bit. So I'll be using my cell phone throughout this meeting. I'm looking up legal terms. I'm not texting my children. So one of the words I came up with was material. And I think material is a legal term that we're all comfortable with. And it's here used in the definition, so I'm going to go quickly. The word material states as true any material matter which he or she knows to be false, and every other person who testifies, declares, deposes, certifies under penalty of perjury that it's false. But we can find a better description of material, and I think material may give us the substantive. What's your thought about that?
All those are possibilities, but again, I guess the fundamental question that I have in light of this discussion is, if we're not for the moment talking about a broader definition of dishonesty, let's for a moment just focus on the specific language of the legislation. If we are only talking about dishonesty relating to the reporting, investigation, or prosecution of a crime, do you still think that we need to put an additional limitation on that to say that even if it is dishonesty that relates to reporting, investigation, or prosecution, we want to put an additional layer of proof on that to say, on top of that, it also has to be material or substantial or willful? Is that where the commission as a whole is going? Because that would be, again, now we're adding an additional item of proof to an attempt to move forward to remove certification on that specific ground. So that's the question. See Commissioner Gordon saying yes.
No,
Yes,
and I'm
of course.
feeling the need for material because I'm very concerned about someone saying whatever else would be dishonest that wasn't material.
Yes, and that's exactly my point.
Okay, other comments? Please.
Will this new board that, will they be following these guidelines?
Yes.
Okay, so their interpretation may not be ours. the-
And
the
then we
commission.
always override them. So
Right,
we get it, we send it to them, they come back with something. We review the material and we think, gee, that is not a reason that we would have suggested, and we're the final word on it.
so, and all the material would be the complete investigations, all of them. So we would know everything before we make that decision, right?
I think I don't know if we know everything.
Well, I'm talking
we
about
would cer-
everything that there is to know that's printed, that's been investigated.
Let me check this out. So my understanding is that we would get the same material that the board gets.
Correct.
Okay, so same material. And certainly we could do further inquiry if there was something, if you got something from the board, you reviewed it, and all of a sudden you wanted more information about that. There can be subsequent investigation, I believe. So I'm looking at you. Subsequent investigation. You pausing? So if Commissioner Barcelona is looking at something, it wasn't something that was handed to the board initially, but it's something else he wants, could he ask for that?
The commission has the ability to direct post staff to conduct investigation. And that would be if you have a follow-up interview that needs to be done or something like that, you can direct post staff to do that. Obviously, we would ask the agency to do it by regulation, the proposed regulations, but you do have the ability to send it back and ask for more.
Does that answer your question, Commissioner?
Yeah, it's concerning to me when it talks about any dishonesty. And I think you get back to the dress question, or, I saw someone take a candy bar or something like that. And I mean, I'm wondering whether that's the level that we want to start revoking licenses for, if it's, because that's any dishonesty.
So if you're saying, is that the level? I think you're going back to this concept of substantive
Yeah.
material. You don't want to hear about the candy bar. You don't want to hear whether she liked the dress or not.
Can we put that in writing? I mean, is that what we're going to do today? Can we put that, can we actually articulate that?
We can-
That's what I mean, I'm looking at the two legal scholars. And
Yes.
are we going to be able to write that?
Well, but again,
Absolutely.
but again,
Okay.
if I may,
Thank you.
we don't have to worry about the candy bar example if we're not going to go beyond this statutory definition in our regulation. So again, if it just relates to, it's going to have to relate to, according to this is limited, reporting, investigation, or prosecution of a crime, or reporting or investigation of misconduct by a peace officer. Those are the only two instances which which the legislation empowers the commission to take action with respect to dishonesty. And well, yeah, I mean, I suppose if somebody stole a candy bar, yes, that certainly relates to, well, reporting, investigation, or prosecution. Again, this is the kind of thing that lawyers have to deal with.
Just wondering how we articulate that. And is it going to go down to that level? Because there's going to be so many lower level types of complaints that could be made. Could be misuse of let's say, you see it all the time. It angers the public sometimes when when my kids are all grown now, but when people would drive to school to drop their kids off, and you'd see a deputy sheriff car drop off a kid, or they would see a car with a knee plate drop off their child or something, and then a complaint, and that sort of thing as well. That would maybe be a dishonesty, and would that come to the point where you?
And again, I think the important thing for the commission to keep in mind is that what the commission is looking at is the question of whether an individual should be certified from being a peace officer in the state of California, period, right? This is decertification. So some conduct may be the basis. It may be a violation of policy. It may warrant some sort of discipline and so forth, but the commission can decide whether or not any given comment should be the basis for decertification of an individual's. And the legislature's given us, again, the basic, those two phrases.
Well, it seems to me there'd be a lot of, I don't know about a lot, but there'd be decisions that we would come to and we'd say, that's a department disciplinary issue and it shouldn't come to this level. Can we make that decision? Is that being made in other states? Are they doing those?
Say it again?
Are other states that already have licensing, are they making those decisions such as we're discussing?
yes, Oregon and a few other states doing that, but let me tell you why I'm now becoming a proponent for adding the word. Because I'm hearing your conversations and I like some of these legal definitions. So material, a description of the quality of evidence that possesses such substantive probative value as to establish the truth or falsity of a point in issue in a lawsuit. Okay, a little elaborate. A material fact is an occurrence, a material fact is an occurrence, event, or information that is sufficiently significant to influence an individual into acting in a certain way, such as entering into a contract. So at least that gives us something rather than the candy bar and the dress. Are you feeling that you would like another word in there?
I just think we need to have room for discretion and the ability to say this doesn't reach the level of decertification and it should go back to departmental discipline.
And as your mind as a chief, wouldn't that be something you'd say, well, that's just not material, that's irrelevant, that's not substantive. Yes, it's dishonesty technically, but no, we're not going to take away your badge and gun because you did that.
Yeah, I think administration should have that ability to do that because people make bad decisions or wrong decisions, but they're not to the level of and you get back to willful or intentional and was it meant to cause great harm and those sorts of things. So there has to be some discretion in there as well. And I think we should be able to do that, to send it back to the department and say, it's not to our level of licensing. This is a departmental disciplinary issue.
I think the commission
Is that
would always,
possible?
the commission would always have the ability, though, to look at any given fact pattern and decide that the commission did not believe that it was dishonesty. So I would think that with the review of any package, that if the commission as a whole looked at it, the commission could conclude, well, we think that this is a matter of interpretation. It doesn't rise to the level of what we consider to be intentional dishonesty or whatever. So again, the question is, to what extent do we need as a body to establish an additional layer of proof to either guide, because we have to do two things. We have to guide the field because every individual in California, every peace officer could be affected by decertification. They have a due process right to know whether or not conduct they engage in is sufficiently severe that it could warrant them losing their right to practice the profession. And two, we have to give guidance to the ALJ, to the prosecutors, to the board, to the commission in terms of whether or not any given fact pattern is a violation of the regulation that's sufficient to permit it to move forward.
Commissioner Brazil.
Yeah, I want to go back to what Toby said quite often. I think we are taking the word dishonesty and applying other things outside of the language that's written here. Unless wearing the dress was actually a crime, which it wouldn't be. I like what you're wearing today, honestly. This is very, very restrictive in the definition of dishonesty and when we can apply it. And intentional is in the language. We may consider defining it a little bit differently, but if you look at the first word in the third line, false statements, intentionally filing false reports, tampering with, I think it's clear that the legislature said intentionally doing these things and filing false reports. And again, it's very restrictive in where dishonesty lies. Stealing a candy bar would fall into a different section in here, not in the dishonesty section, unless they lied about it in the internal affairs investigation or in a report. So I think it's important for us, just my own opinion is the title is dishonesty, but the language when it's applied is very, very restrictive and very tight, in my opinion. We might want to change intentional somewhere. I understand that. But it's related to reports, filing reports, tampering with evidence, those type of things, which is really egregious stuff and wouldn't apply to, I called in sick. I like what you're wearing. That wouldn't apply. We would never see that here.
So if we were to hone in a little more, and then I'll get to commission. So I wanted to say this before you speak, Commissioner Long, so I want to know what you think about this. So if we did dishonesty, then wrote dishonesty is a material intentional, okay. So dishonesty, a material intentional act of dishonesty relating to the reporting, blah, blah, blah. So we'd be adding a material intentional act of dishonesty relating to. That would be words we could add, which could hone it in a little, but is not taking us into every specific. So we have intent and we have material. Commissioner Long.
Yeah, just for for you reading of the room, I think I want to associate myself with Rick's comments and also Toby's in terms of going back to the definition. It's not just the word, it's everything that follows, but also I think it's also important to take a look at the workshop A and B and look at, what the law enforcement groups have told us and what the advocates have told us, and both said it should be intentional and willful, so I think working that in there would be also a nod to our, working with both of the workshop groups, both of whom were, brought a lot to the table. So I think that's worth noting.
So in doing that, Commissioner Long, it would just be dishonesty, a material, intentional / willful act of dishonesty relating to. So using their language in there, owning it a little more. I see a couple of nods. This side of the table, how are you? Any thoughts over there? Okay. Commissioner Yule, how you feeling about this?
I think Commissioner Long has expressed my thoughts, quite frankly. I think adding those two preambles to the language would satisfy my needs.
Okay, anything else on just, so right now, what I'm hearing, and then we certainly haven't finished dishonesty, is dishonesty, period, a material, intentional / willful act of dishonesty relating to the reporting of blah, 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 blah. Anybody uncomfortable with that wording? Okay, so who's Carrie or who's going to do it? Katie, would you, I'll say that again, and this is just going in the notes section. This is nothing that we voted on or anything. It's just a thought that this body has had, which is dishonesty, and then it would be a period. And then the sentence would actually start with a material, intentional / willful act of dishonesty. And then the rest would go back to the regular body of it, relating to the reporting, et cetera, et cetera. Slow down.
Trying to type.
I'll try it again. Dishonesty, period. A material, intentional / willful act of dishonesty. Then it goes back to the body that is written, relating to the reporting, et cetera. Would you, / willful, yeah. Okay, that's a thought. That's a thought we're all living with at the moment. Other issues relating to dishonesty, having reviewed workshop A, workshop B, and your own thoughts. Yes, please. You two jump in anytime. Don't ask, may I?
All right. Yeah, and if I may ask
Please.
for permission, if we could have one of the bureau chiefs come and sit up at the table, Jackie Nelson, if we
Sure.
could, because she's going to have to be the one
Please.
with one of our other bureau
Yeah,
chiefs, putting this together in case she has some questions or concerns. So one is this on duty, off duty? Does it apply? That's a question that should come up. And then going back to some of the comments or the questions from Commissioner Barcelona about how other states do it. Other states don't have this broad, these 9 categories. They're not that broad. They're more specific. So it's easier, I think. The commission, the board in Arizona, staff have to come to the commission, say, here's a fact pattern. Do you want us to look into this further? That's not the case here. Here, we have to bring it to you. So as Mr. Darden mentioned, we want to clarify it for the board, the commission, and the ALJ, but we also need to clarify it for post staff because we want to send, we don't want to just throw anything at the wall. We want to send to the board what you all want us to send, what you think is decertifiable. So the language definitely helps us as well. And I just want to emphasize that because we will be the first ones to take a review of it.
And if I may as well, when we're putting language like this up on the board, I just want to make sure, I think that we understand the overarching concern that the commission has. But when we sit down to actually draft the language, for example, as a lawyer, it kind of gives me fits to see intentional/willful, because again, intentional and willful may have different elements of proof, which may be different from material. And so now my question is, do I have to prove all three, and what's the basis of the definition? So I hope that the commission is, what the commission is doing is giving us guidance, and that understanding the guidance, we can then try to put together the best regulatory definition that is in accord with the spirit of the guidance, but maybe not necessarily follow that exact language if that would be problematic from a proof perspective.
And I think the slash would certainly be a problem. So it would be, you'd have to be a comma because they are two different legal positions. And your thoughts, Jackie?
Actually, I don't have anything specific at the moment, other than the one difference between the two work groups was work group A wanted only on-duty conduct to be addressed, and work group B wanted both on-duty and off-duty, and that's a consideration.
I'm not sure if you could take it up or what the problem is.
Can you hear me now?
I think so, but let's try it again.
Okay.
Distinction between workshop A and workshop B in terms of what?
Yeah, workshop A wanted the dishonesty actions to be solely based on-duty conduct, and workshop B wanted to include both on-duty and off-duty. And so just for discussion, clarification for this board to consider. Thank you.
Okay, thank you. So I'm going to put Commissioner Donilon on the spot for the fun of it. On duty or off duty?
Thank you, Madam Chair. I would just, if I can digress for just a second, because the first time I have the floor, I want to thank Manny for his remarks. And also you'll note that he thanked many people, ALGJ, the governor's office, etc. I want to thank the members of the post staff. This is a staggering lift. Even just sitting here as commissioners, we're dealing with just a paragraph and it's taken us over an hour. And just think for a second about how much the staff here are trying to lift this significant issue to get it up and running by the 1st of January, I think is a feat that I am confident is they're all going to make, but I'm very respectful and humbled by the amount of work that's going into it and appreciate it. And then returning to this.
No, I want to interject now. I'm so glad you said that. You speak for all the commissioners in saying that, so thank you very much.
I think everyone here, whether you're have a title by your name or a department head or working its post, are all on the same page trying to get this over the goal line, and I appreciate everyone's efforts. I would say, just for me on a whole, and listening to what Toby has said in particular, where I'm going to lean is what's written by the legislature and what's written there. And you had 2 ways of moving forward for the day, Toby. For me, the outline is already there. It's in the legislation. It's lined out. You look for an overarching definition of serious misconduct. It's these 9 particular items, and that's it. And becoming overbroad, I think, is a mistake. And we don't know where this is going. Speaking to Commissioner Barcelona's comments, we don't know where it's going ultimately. And I think we have a blueprint in front of us in the legislation to get this up and running. And it'll serve us well if we stick with what we were given from the legislature. That's my humble opinion. And I think muddying it just makes it more and more challenging for both a servant cop and for those who are going to sit in these seats years from now and generations from now.
Let me suggest that in some ways it can do that, but in some ways it can simplify. For instance, the question about on duty or off duty. That's kind of black and white and gray, but it's more black and white than most things. So what is your thought, Commissioner, about what would the dishonesty we're talking about? Let's say it's absolutely dishonesty and it's a material thing, but it's off duty.
This goes back to the comments that Commissioner Braun brought up from my perspective, where you go out to a function and your wife's dress isn't the greatest, but you say it is. And I think you focus on what our duty is and our service, and it's on duty.
Okay. Commissioner O'Rourke, your thoughts? Thank you.
Yeah, I actually couldn't agree more with Barry there. I think it should be to on duty.
Does anyone think off-duty? Yes, Commissioner Brazil.
I don't, well, let's hypothetical this. So off duty, I can go in and tamper with evidence. And if I do it off duty, it's not dishonesty. Again, the language is very specific. It's false reporting, it's tampering with evidence. I don't know how you can do that off duty. I mean, it's not about whether you're on duty or off duty in this one. It's if you're either tampering, you're destroying, or lying in a police report, or you're not. It's because it's very specific to that.
That's exactly right, Commissioner. And so my thought on that one is that if the commission wants to say on duty only, it certainly can. But what that means is that if you have an officer when off duty that files a false report of a crime, then we would not have the ability to look at that and potentially take action with respect to certification because we've limited it. If we don't take that action, we do not limit it to on duty only, then the commission would have the jurisdiction to look into any instance in which it's dishonesty that related to the reporting, investigation, or prosecution of a crime, whether on duty or off duty. And the same thing, the investigation of misconduct. So it may be, all of you have been involved in IA investigations. It may be that, an officer is interviewed. Well, no, I suppose if they're interviewed, they're actually on duty, aren't they? But just in some instance in which the investigation of misconduct by a peace officer there's dishonesty with the officer somehow being off duty. And if we do add that language, then we're limiting what the commission can do. If we don't add that language, then we just go right back to what the legislature has said. Is it dishonesty? Does it relate to reporting, investigation, prosecution of crime, or reporting, investigation of misconduct by a peace officer? If it does, you have jurisdiction.
Yeah,
But again, the commission can certainly limit it if it wishes to.
Madam Chair, I would agree with Commissioner Brazil. And I think, again, it goes back to my remarks that you stick with what we've been given in the legislation. And I think Commissioner Brazil's points are right on the money.
So in a situation where two officers go out for a beer later that day and they're both off duty and one officer discloses something that they did and the other officer does or doesn't report it. Well, they're both off duty, but he's hearing about it or she's hearing about it then. And therefore, we do think it's an act of dishonesty that they wouldn't report it even though they were off duty. That's where I have trouble making that distinction. Let me go back to you, Jackie. When you were talking about on and off duty, do you think is specifically to dishonesty or to other ones?
Well, I think that is a consideration that came up through the different work groups in all 9 elements for this board to consider, or this commission to consider. So I would just keep that as an open-ended discussion point for you as you work your way through each of these 9.
My sense is that we've heard enough about this particular issue as it relates to dishonesty. And even though we all feel this, it should be an on duty. As soon as we hear these stories about off duty, tampering with evidence, any of the other issues, because they are rather specific here, then it gets a little murky. So does anybody want me to add on duty to the statement?
No.
Okay, great. Any other concerns, Jackie, as to the dishonesty?
No, I think that that was the biggest sticking point between the 2 work groups. Thank you.
Maria, anything? Okay, back to the commissioners. Anything else in the paragraph on dishonesty that you want to add? Okay, we've reached an hour and we have this fabulous court reporter there. And we're going to give her a break. So we're back at this at 10:15, please. Thank you. Okay. Okay, everyone, if I could get you to take your seats and continue with the next one, which is abuse of power. And that is on both page 2 and page 3. So if you could start off by reading it to yourself, both the definition of abuse of power, as well as the workshop A and workshop B recommendations. I'm waiting to see everyone look up when you're ready. Okay, I'll start for just to starting off. I would probably want to add the word knowingly in front of intimidating witnesses because it's conspicuous in my mind that knowingly is in front of everything else, but not that. I know that each of us have experienced times where we have intimidated somebody and we didn't realize we intimidated them. So I think it has to be a knowing, which is a pretty low level in law. It has to be an awareness of. Anybody think that we shouldn't add the word knowingly in front of there? Am I intimidating you?
No, just to speak for, I expect everybody, I agree, because just a uniform in and of itself can be intimidating.
Exactly.
Yeah.
And we never know what psychological experiences other people have had with whatever it is we're saying or doing. So it does. The other piece that I thought about when I was reading this was workshop B spent a fair amount of time on the abuse of public office. They talk about that in B, C, and D. And as I went back to the definition of abuse of power, I looked at intimidating witnesses, obtaining false confessions, and knowingly making false arrests. But what they referred to in B, C, and D was abusing the public office, your public office, both your powers and abilities, because there are some things as law enforcement officers, we have some abilities to do, and there's some powers that we have. And so putting in a term about public office powers and abilities seemed important to me, and certainly it's in deference to workshop B, but it also feels right. Thoughts about any of those things? Toby?
Yes, I agree completely with that. And the reason is that, again, I was explaining this during the break. If the commission takes action to revoke the certification of an officer, ultimately that decision can be reviewed by a court of law. And the court of law is going to look at it to see a couple of things. First, the question is, did the conduct demonstrate unfitness or lack of confidence to serve as a peace officer? And then the other issue sort of gets into this question of on duty versus off duty. It's the nexus question, right? Is there a connection between the conduct and the job? sufficient that it comports with due process in the law for the commission to take action to remove somebody's ability to practice the profession. So when I look at why did the legislature put abuse of power into this definition? Well, it's a peace officer. And so I think that the power, they're not talking about the power as, you know, in a household dynamic, right? They're talking about the power of a peace officer, and the individual is abusing the power or authority that they have by virtue of their public office. So I think that is in some ways implied by a necessary implication, but it makes perfect sense to me that we would want to add that in.
Okay, so
I have a question for Toby. Toby, one and the chairperson, it's a legal question. If they illegally access databases, need to know, right to know, or they solicit somebody to do that, doesn't that fall under acts that violate the law? And why would we add that if it falls under acts that violate the law?
because they can legally access it because of their public office. It's the intent of why they're doing it. And the intent in this case is for their own private whatever. So they're abusing their powers as a public officer.
But if it's illegal if they do it for their private reasons.
Correct.
That's already a violation of the law. So again, I just feel it falls under acts that violate the law.
And it may very well be, if you don't mind, it may very well be that we have a fact pattern that might fall into one or the other, or maybe you could even prosecute it under one or the other grounds. But the question is, we do need to have an understanding of how the commission views what an abuse of power is for purposes of this definition, right? So when a given fact pattern comes to the board or to the commission, then we need to have some understanding as we look at that fact pattern. Okay, first question, is it an abuse of power? And then the next question, maybe it's not, and then maybe we go to the question of it violating a law. So, so again, I think it's a useful exercise for us just for the commission to express to staff sort of how it sees what an abuse of power is, because we will need to know what it is when we look at a given fact pattern and see, does it fit under number 2, abuse of power or not?
Good question. Yes, Commissioner Purcell.
I have a legal question again. A comment one, I like the change you made first. When it says, but not limited to,
Yes.
because the language has, these are examples, but not limited to.
Correct.
Would fact patterns that are not violations of law, but not listing a specific example here, we could still bring that forward. In other words, using surveillance stuff, we don't need to identify it. We can look at it because you've got others in here.
Yes, Commissioner, that's absolutely correct. And, again, I think it does make sense that we could tie the abuse of power to the abuse of the office, right? And so the example that you gave would be an abuse of the office, therefore it would be an abuse of power, and it would be actionable even if it didn't arise to a violation of a statute, because that isn't a requirement in abuse of power independently. Because again, this is just the question of, okay, we got to look at a fact pattern and look at number 2, does it fit or not? And so under that circumstance, yes, absolutely, that would be actionable.
Because I strongly share Commissioner Donovan's view that the tighter we stick with the legislation language and the intent, the better off we are for you legally and everything else legally. The only thing I would add on this for consideration, and maybe it does apply with the but not limited to, is it's knowingly obtaining a false confession. I honestly think it should be statement, because confession implies it's a suspect versus just anybody. But that would be the only thing. And I don't know if it qualifies with the but not limited to, but that's the only thing I saw maybe in the language. The legislature didn't distinguish between the two.
Thank you. Other comments? So we have 3 changes that we're suggesting here. So the first would be, before you type it, let me just say it out loud to everybody, because I think there is a little bit of disagreement. So and we can, even if just the majority of us feel one way, it's okay to put it up there, because ultimately it'll come back to all of us in May for a vote. So the changes would be as follows, if we wanted to make all of them: abuse of power, comma, including but not limited to, comma, adding the word knowingly, so it's consistent with everything else. So the word knowingly would go in front of intimidating witnesses, then knowingly obtaining a false confession, and knowingly, what were you, Rick, I'm sorry. you didn't want to change the word obtaining.
It'd just be statement, because confession to me is just with a suspect, but
Yes,
statement includes everybody.
I understand now. Knowingly obtaining a false statement and knowingly, and take out the word and, so it would be, again, just to confuse us all, knowingly obtaining a false statement, comma, knowingly making a false arrest, comma, and knowingly abusing the powers and abilities of their public office. I believe that Commissioner Brazil's thought was, we really don't need that latter one. I still feel like when something is entitled abuse of power, that we really should put that in, even though, as Commissioner Nieto said, doesn't that already comport? Or as Commissioner Brazil said, it falls under the idea, but not limited to. I just think it tightens it up a little bit. It makes it a little easier for people who are looking at abuse of power to also consider, and don't abuse your power.
Madam Chair.
Regulatory perspective, I think what I would say is that we might want to, if we we're going to do that, I think we might want to say abuse of power is a, whatever the wording is, a violation of the public office. So we're making clear that's what abuse of power is. And then you can say, have examples, including but not limited to. And we can certainly add false statement, although it's probably already there within the including but not
So
limited to.
Toby,
We can
your
certainly
words
add
would
it.
be abuse of power. Give it to me again. Is,
Well, and I'm sorry, you had said you had
I
the
had
language
knowingly
with respect-
abusing the powers and abilities of their public office.
Right, so it would be abuse of power is a, and then we would have that language, right?
Knowingly abusing the powers and authorities of their public office.
Right.
And then go
say
on to the
comma,
knowing.
including but not limited to.
Okay. So that's another thought. Commissioner Donaldson, did you have some thoughts here?
Yes, Madam Chair, I'd go back to my remarks about sticking with the language, and I think that your point is right on the money, but I think it's already included with the words not limited to. But I would be comfortable with adding knowingly, and I totally would understand Commissioner Brazil's comment about statement. I think it's absolutely applicable.
But more importantly, do you like my dress?
Having gone through
Dave Levity, you want to make a comment about my dress?
Yes, it's beautiful. Thank you.
Yes, you have another comment?
I do. We can add to, but not take away, as just a reminder. So we
Oh,
can't
that's right. We can't
take away confession. We can add
Thank you.
to that.
Okay. Thank you. Commissioner O'Rourke, anything about adding what we've discussed?
No, I think we need to limit it to what the legislator's saying, and the recommendation, the but not limited to, I think covers the last, what you were suggesting. I do like the knowingly and then the false statement or confession.
We can't do that because we can't change the word confession.
Right.
Okay, anybody else want to comment on whether we want to add that? I think we've all agreed to knowingly. Now do we want to add the provision at the end of knowingly, either in the beginning, abuse of power is knowingly abusing the powers and abilities of public office or not? Commissioner Braun.
I say yes, and to make it clearer to line level law enforcement, because the temptation is great, especially for CLETS violations, to just run somebody or just find that piece of information and everybody knows that it's wrong, but to make that clearer in serious misconduct, that there's the very serious ramification of losing your post certificate. And I was on board with Commissioner Nieto initially that would be covered under other violations of law, but it is an abuse of power. So I don't think that it would be wrong to add that here.
Anybody else have any comments, other comments on that? Okay, I would suggest then we put it in the notes as Toby suggested it. And again, the staff will have an opportunity to actually write it up and take a better look at it, and then we'll have a chance to vote. So we'd be adding the words in the whiteboard. Abuse of power is knowingly abusing the powers and abilities of public office.
Is it powers and authority of public office?
Yes, thank you. Powers and authority of public, and is it of their public office, of public office in general? How would you deal with that?
I might actually leave it public office.
Okay. So I'll say it again slowly now. Abuse of power is knowingly abusing the powers and authority of public office.
comma, including but not limited to.
And then comma, and then we go back to the language that's there, including but not limited to, comma, and then we add the word knowingly before intimidating witnesses.
And then if I can make a suggestion, I think we could add Commissioner Brazil's very easily by simply saying knowingly obtaining a false statement or confession.
Nice, nice.
I have a statement to make.
Knowingly, okay, that's good. False confession or statement, and then
True statement.
comma, and knowingly making a false arrest, which is already there.
Toby?
Yeah.
Does it matter if Government Code Section 5324 3.3 says his or her office or position is called out that way in that Government Code section?
Problem is, if anytime we do his or her, we really should do his, her, or they. And so then we're going to be putting in a lot of pronouns.
I understand that. I didn't know if that was something that had to match up to the Government Code.
I actually think we're okay.
Okay.
Yeah.
But this is great. And I really would love, I love the idea that staff and commissioners are jumping in because we can't go back. It's too complicated. So any thoughts you have about this, really now's the best time. Hearing nothing, we will move on to 3. Okay, so 3 is on page 3 and page 4, I believe. Yes. So if you could take some time to read about physical abuse. Okay, this is pretty meaty in terms of workshop A's and B's comments. Let me start with just a series of questions, perhaps as related to them. There was a discussion that it should only be physical abuse, including but not limited to the excessive or unreasonable use of force that results in serious bodily injury. Does anyone feel they want to add that provision, serious bodily injury. Okay, hearing nothing, we will move on. There was another discussion of the word intentional. So in that case, it would be physical abuse, including but not limited to intentionally using the excessive or unreasonable use of force. Anyone think we should add the word intentional there? Okay. Didn't hear anybody responding to that. I guess I want to comment on that one. I could see how someone would be trying to arrest someone and they would be trying to put their hand down and they would hit the person in the head with their watch. You know, certainly didn't intend to hit them with a watch, trying to get their arm behind them. Do we want to, so if it, right now, the way it's reading is that they're using excessive or unreasonable use of force. My suggestion is that there was no intent to use excessive or unreasonable force. In the fray of the moment, the watch hit the head and that caused the injury. Thoughts? Say it again. You think the word intentional should be added?
Yeah.
Okay. Yes. Commissioner, yeah.
Some of it's not intentional. I mean, most of us who've been in fights over the years and on duty, you know, wrestling with drunks, et cetera, their injuries can occur that aren't intentional.
Yes.
So I think
That's why I brought it up twice, because I want to make sure everybody's on the same page, because I was very concerned about
I
that.
like workshop A's comments. I think intentional is correct.
Okay. Anybody not comfortable putting in the word intentional?
If I can ask.
Please.
Is that a limitation only on excessive or unreasonable use of force? Or is that a general limitation on physical abuse? Because the reason that I ask is that workshop B included some aspect of the idea of a failure to intercede
I want to talk about
or a
that
denial of
separately.
medical care.
I definitely want to talk about that separately, but I think your question is similar to the question you raised with 2. Which is after the words physical abuse, we could put the word intentional versus where I put it. So it'd be physical abuse is an intentional act, including but not limited to the excessive. And then if your definition of physical abuse, intentional act, the beginning, or what were you thinking?
Yes, you could absolutely do that. Again, with the decision that the commission needs to make is how does it want to limit it? Does it want to include acts which might include a denial of medical care, a failure to provide medical care, a failure to intercede? That may or may not be inconsistent with intentional language. We'd have to think about it.
But wouldn't that be consistent if someone would have to intentionally have denied them intentionally? So I think we're still okay there. So the only suggestion we have so far is physical abuse, comma, an intentional act. So it would just be the words "an intentional act."
Madam Chair.
Yes.
Just as being a contrarian here.
And can you make sure your mic's on?
Yes,
Speak.
does that then imply that my argument that everything that I did to abuse someone was not intentional? And how do you prove that it was not intended?
Describe the scenario so we're all on the same page.
You body slam someone and you say, but I wasn't intending to hurt them, but I was trying to control them. When in fact-
Intentional only means that you intended to slam them in law. So an intentional act is an act you intended to do. The repercussions of that act are irrelevant. So when you said, you started off the sentence with, I head slam them, is that what you said?
Yeah, I just body.
Whatever, head slam, that was an intentional act. You did not intend to injure them. I don't care whether you intended to injure them, but you intended to slam them in the head. That's how the word intentional is used. You want to give it a crack?
No, I agree with that. That's 100% correct. Intention just means that it was volitional. You intended the act that you engaged in. I think really the question is, what is abuse, right? Because a peace officer may intentionally take someone to the ground, and yet that's completely a reasonable and appropriate use of force under the circumstance. So I think the question, certainly intentional is an element of it, but I think more fundamentally, the question is, what is the commission going to view as abuse?
But doesn't that then get answered in the second part of that sentence, which is excessive or unreasonable use of force?
Well, yes, insofar as that, but that's only one example.
Right.
So really the question is, what is physical abuse? And we kind of need to define what that is. Now, I suppose we could just say, we could just leave it the way it is. And then it's just a question under any given fact pattern, if the commission believes that that would be physical abuse. But the idea would be, can we expand a little bit more on what we envision physical abuse to be, with the understanding that excessive or unreasonable use of force is an example, but it's not necessarily the only example, because the legislature's told us it's not the only example.
Going back to you, Commissioner Yule, what are your thoughts having heard this discussion?
And I'm just a little concerned of having to prove the intention or defining the abuse. I mean, I'll give a very wild example. With the George Floyd case, standing on the neck, you can argue that wasn't my intent to kill him. It was to control him. And so how do you start to parse those types of?
I always go back to the first act. So if someone's putting handcuffs on somebody, and it turns out that because of their veins or arteries, that their act of putting it on was an extraordinary situation where some terrible things happened, that isn't an intention to cut off their blood and their wrist. The intention, but where the intention comes in is they click it twice, so it hurts. So I don't care about the damage that follows is the damage that follows, but the intention was putting on the cuff and then clicking it twice. So we always have to go back to the first act. Driving under the influence is just an intent to drink and then drive. After that, you violated the law. So for me, intentional is the intent to act, but keep talking to me. I'm sure we're communicating.
No, I understand your point. I just have trepidations about the whole issue of trying to determine what that intent was. And I mean, for me, a lot of these things, and I'll actually align myself with Commissioner Donlin in this case. A lot of this is, I mean, when you go through the different levels of review and it comes to this commission, I mean, they can push it back and ask the questions or ask for clarification on things. But if we're tightening this so tight, then it makes it almost impossible to catch those who become very clever, and they will over time, to try and obfuscate the intent of this language or this bill. And so I just worry about trying to tighten it a little too much.
And I think that is the balancing act we'll be doing all day today, because we want to give the people in the field, as well as the commissioners, enough specificity so that they know what they're doing violates the law, but not so much that it restricts anybody else's opinion ultimately about their act. But I think putting in some words is good and too many is bad, which is why this conversation is so important.
And if I may, I think it's important, your point's an important one, because we can't tighten it so much that we are subtracting from what the legislature already gave post the authority to do. So, for example, as we were talking about on duty, off duty, if we added a regulatory provision which arguably took away power that the legislature gave us, we can't do that, right? So we are stuck with what the legislature gave us. So I agree completely. We can't tighten it so much that we are restricting or removing what the legislature has already told us is serious misconduct, because it has.
Commissioner Gordon. Your mic.
I'd like to take that statement that Toby just made one step further, because, you have workshop B that added some additional suggestions, but those are actually already legislated items. The duty to intercede, the duty to render medical aid, they talk about domestic violence. That would be a violation of number 6. When it comes to, acts that violate the law, there is a clear legislated standard in terms of use of force now. So I wouldn't want to create language that now contradicts in any way with what that is legislated. Because chances are what is legislated will probably change. I mean, if you even look at the bills that are, going to go through this cycle, that legal definition could get loosened, it could get tightened, things could happen with it, which then means you have to come back to this regulation and make changes to it. So I would actually encourage us on this one to really stick with what is written as it is written, because excessive force and that consideration, if I'm reviewing a use of force where an officer strikes someone, the strike was intentional and it was reasonable. Unfortunately, they had a wristwatch on and they caused physical damage. They caused a laceration with that wristwatch. That force was not excessive. I'm not proving whether that's an intentional act or not an intentional act. That was as a result. That strike was a legally justifiable use of force. And that's the standard that we're looking at in terms of when we review a use of force, which is not only our department standard, is what is legislated for us to look at. So I would hate to add additional wording to this. I would actually encourage us to leave this one as it stands, because I think there is a clearly legislated responsibility. And when it comes to that, I would hate to start adding different terms of what physical abuse is, because although all those things that workshop B said are valid, like domestic violence and other things, they actually are legislated and covered by other parts of the 9. If someone commits domestic violence, on or off duty doesn't matter. I mean, that is the standard for what that means for prosecution. It already exists. For the inability, the failure to provide medical care, that already exists. That duty to intercede with the new legislation already exists. So I would encourage us to stick with, in terms of this particular one, exactly as it reads.
Okay, other thoughts? I'm still of the school of thought that we should add a little bit more, because it's not a problem in my mind if we have multiple avenues. One of the things that our communities and all of us are very concerned about is when the image that a law enforcement officer would not intercede, or that a law enforcement officer would not seek medical care. So from my perspective, even though I agree with everything everyone's been saying, I'd be a little more comfortable with it if it said, including but not limited to the excessive or unreasonable use of force or the failure to intercede or denial of medical care. But that's just lawyers who love words. More thoughts? Yes, Commissioner Long, then Brazil, then Nieto.
I would, in general, default to the Donnellan principle and all of this, but I do think it's important to it, where we can add something from both workshop A that does not detract or conflict or cause us damage. I do think that there's value in nodding to both workshops where we can do it. And so I would be.
So Commissioner Long, what would you like, if anything, to add to this?
I would agree. I'd be fine. And notwithstanding the Donnellan principle, which I think is overriding, I would think that your suggestion does give some credence to the workshops, which I think is also important.
Thank you. Commissioner Brazil?
One, I'd leave it the way it is exactly. I support I would leave it the way it is exactly. I have a different question though for Manny and Maria. So when we're done with this and we've got a new group coming on, are we creating training programs or manuals? Because I think some of the stuff goes into the training, meaning when we review cases of physical abuse, we need to take into consideration, was it intentional, not intentional? It's more of the application of this. So I think we're trying to do both, but are we putting training curriculum together for the new board that's being formed and or commissioners on how to manage this stuff?
I'll take it, Maria, unless you'd like to. Yes, the answer is yes, Commissioner Brazil. So Senate Bill 2 has a requirement that the board members receive 40 hours of training. We are in the process of developing that training curriculum. We anticipate that it will be 24 hours of classroom-based training and 16 hours of training at post, which will include these specific topics and a review of this material. So yes.
Yeah, so that's, I would stick with the language, and then we adjust and do the little nuancing thing and how we handle it and how we look at the training piece for the board coming on. Because we can what if all the different scenarios. And I totally understand what you're talking about with, I knee across his neck. There was no intent to use excessive force. I was just trying to keep him on the ground. But in fact, the agency would say that was excessive force. I just don't want to create those dilemmas.
A knee on his neck. That's where the analysis ends for me as an attorney. He chose to put a knee on the neck and keep it there. The fact that he died is not intent, but the fact that he chose to do it was the intent.
Correct. No, I agree with you 100% on the legal aspects of it.
Right.
But the claim is I didn't intend to use excessive force. I was just intending to hold him down. So then versus we just say use excessive force regardless of what you thought your intent was. We still determine used excessive force. That's why I think we keep it clean with just the language. And then we can have those conversations if it comes to us for a review about intent and did they have intent or not have intent and go from there. This is one of those, I think and I agree with Commissioner Gordon, keep it really tight. I understand that we want to kind of give value to the workshops and I do read those and I did look at it and say, yeah, you came up with all the exact things you should have. They're already in law, so they probably just didn't know it. But they came up with all the things that were appropriate. They just didn't know they were in law or potentially in law. So.
Okay, Commissioner Diento.
So I agree with the prior comments. The Donnelly Act, I guess we're calling it now. But I stated this in our last commission meeting when we were all together, is that I think there is legislative intent. I know we can clean up the language a little bit, but I am a little reserved when we start adding things to it because you have a lot of leniency as if you're head of an agency when you're looking at these complaints. And intended or not, if it's excessive or unreasonable use of force, that's going to be a sustained complaint with agencies. But I understand the lawyers in you and I'm not a lawyer. So I just think we should stay as close as we can to what the legislation stated. And that gives the commission, it gives the investigators, it gives the agencies a little bit of leniency for interpretation.
Anything else? Jackie, you do something? No. I'm going back to when we have a topic called physical abuse, and then a law enforcement officer sees that and says, yeah, well, I didn't use the physical abuse. I didn't do it. I didn't intervene, but I know later on it's intervened, but there you had physical abuse and nothing about the bystander. And I didn't call the ambulance because I thought that was the sergeant's job. I just don't think we can say those two things enough. So I think we have differing views, but let me articulate the differing views. One is to leave it alone completely. The other is to merely add the word intentional. So that would be physical abuse is an intentional act, including but not limited to. So again, just adding the word intentional. And the third would be including but not limited to the excessive or unreasonable use of force or the failure to intercede or the denial of medical care. So I think the easiest thing to do here is a show of hands. So let me see a show of hands for people that want to make no changes whatsoever. One, two. Are you raising it for Rick?
Rick.
But you're not raising it for you. Okay, 1, 2, 3, 4, 5, 6, 7. Someone said 7, 6. Okay, who wants to put your hands down? Who wants to add just the word an intentional act? 1. Okay. Who wants to add the other parts about, let's see, interceding and medical care? Just me, Jeff. Okay, well, obviously, then the group in general feels that we should leave it alone. Okay, thank you, everyone. That was a little bit, I'm glad that we're having these discussions. That's what we all care about. All right, so let's see if we can do one more. What's the timing on lunch, Carrie?
11:30, 11:45.
Perfect, okay. In 12 minutes, it'll be an hour. How are you doing, Kathy? You want to break now or in 12? Okay, fine. Then let's go on to sexual abuse. And just to remind all of you, that's on page 4 and continues to page 5. Yeah, we need the definition of 832.7. I can get it on my phone.
Yeah, I have it.
You have it
But
too?
we should put it up.
Yeah, we should put it up. We putting it up?
Yeah.
Whoa. Okay. I'm old. I can't read those little letters. Let's see. How about Carrie? Who has that in front of them? Okay, sorry, darling. Would you mind reading that out loud? All of it? I think we need all of it.
Well, it's B2, so it's as used in the subdivision, sexual assault means, and then as
Yes.
used in the subparagraph, member of the public. It's really those two.
So it's 832.7. Stand by.
Would you like me to read B?
Hang on. I wanted to make sure.
If you'd like, we
It
can print
says,
out.
it does, it says 832 points, yeah, section B, and then 7, correct.
So it's
but-
just B.
I think you also have to read the first paragraph.
Right, and
So A, yeah, okay, you got it. Manny, you didn't do it?
okay, sure.
Okay, thank you.
Okay. All right, for 832.7A, except as provided in subdivision B, the personnel records of peace officers and custodial officers and records maintained by a state or local agency pursuant to section 832.5 or information obtained from these records are confidential and shall not be disclosed in any criminal or civil proceeding except by discovery pursuant to sections 1043 and 1046 of the Evidence Code. This section does not apply to investigations or proceedings concerning the conduct of peace officers or custodial officers or an agency or department that employs those officers, conducted by a grand jury, a district attorney's office, or the attorney general's office, or the Commission on Peace Officer Standards and Training. That is A. Now
Okay.
go to B.
So now B7.
B7
So
is what you would like me to
I think we
read?
have to scroll, can we scroll down so I can see where 7 is?
No, it is in B7.
B7?
Madam Chair, no,
It's
no, it is in-
832.7 subsection B, right? Okay, so it's everything in B.
Well, and if I may.
Please.
Madam Chair. So the Senate Bill 2, what it says is sexual assault as described in subdivision B of 832.7.
Right.
So it strikes me that really what we need to look at is the description or definition of sexual assault in 832.7B.
So is
So
it B1
helps.
only?
Yes, I think it is B, and actually it starts. at
One,
B2
two,
and
three.
B3.
Okay,
So it's as used in this subparagraph, that's the one, and then the member of the public. So it's those two. In my view, that is the definition or description of sexual assault in 832.7, which the legislature has pointed us to.
I agree. So do you want to read that out loud, Toby, so we're all on the same page?
Sure. As used in this subparagraph, sexual assault means the commission or attempted initiation of a sexual act with a member of the public by means of force, threat, coercion, extortion, offer of leniency or other official favor, comma, or under the color of authority. For purposes of this subparagraph, the propositioning for or commission of any sexual act while on duty is considered a sexual assault. Subparagraph 3, as used in this subparagraph, quote, member of the public, end quote, means any person not employed by the officer's employing agency and includes any participant in a cadet, explorer, or other youth program affiliated with the agency. This is language, by the way, that was all put in by the legislature in Senate Bill 1421, which was the provision that carved out and made these records public.
Okay, so let me ask you, Toby, so that others can hear your answers. Does that include use of sexual act under the color of authority? As,
Well, that is specifically included in
Right.
the first sentence.
Right.
As one of the impermissible acts of sexual assault.
so I heard them all there, but let me just go through it. Overwhelming power differential or dynamic tilts towards an officer must be considered. Do you feel that that's being addressed?
I'm sorry, we're on the chart now.
We're on the chart, but we're looking at the language.
Okay.
And one of the things that workshop B talked about was overwhelming power differential, be it because someone is a vulnerable population or not, or dynamic tilts toward an officer must be considered.
Well, looking just at the language of the statute, what I have seen, the limitations that I see, the primary limitations is the member of a public. That's the first one. Because the legislative definition talks about the member of the public, and it does include someone not employed by the officer's employment agency such as a cadet, explorer, or youth program. So that would be a member of the public. It does not include, though, a member of the department.
Right.
So sexual assault by one officer upon another officer would not be included within the definition. Otherwise, the only definition is means of force, threat, coercion, extortion, offer of leniency, or under color of authority, with the exception that as long as it's on duty, that's considered a sexual assault. So I'm sorry, the question then is. does
No,
that
I
consider the-
think that was an important one.
Okay.
That was a very specific one. So when we talk about the 832.7 talks about member of the public. What if it just said anyone? Oh, we can't take out words. Since we can't take out words, I don't know how we broaden that. I guess it could be, we can't add to the 828, we can add to the definition of sexual assault pursuant
Yes.
to serious misconduct. We can't
Yes.
change 832.7.
If I,
Correct,
if
you
I
still
may
can't
share
take it
that,
away.
would that fall under abuse of power then? If you had, say, a superior officer, a quid pro quo situation with a subordinate, could that fall under abuse of power with the power differential? So say a captain has an officer, say, if you want this position, not that that would ever happen.
But I'm not sure it always is direct power. Sometimes it's just someone's been a sergeant for a longer amount of time, or they're two equals.
Right.
I mean, I think if
It
it's
just-
sexual assault,
The legislative intent seems very narrow on this, where they specifically called out this section that I would feel uncomfortable adding to it.
That's just narrow but clear.
Commissioner Long, I couldn't hear you.
I would say agree with Sheriff Braun, but also it's narrow, but it's also, to me, very clear like it or not, it references one specific penal code section and period, which does not, to me, seem that they're inviting exposition.
We can, as you know, Commissioner Long, add to, after the word sexual assault, we could add anything we want, and then we could say, as further described in subdivision, or as described in subdivision B, in addition to. So we can still mess with it a little bit. Is there something that you'd like to add or?
Madam Chair.
Yes.
Yeah, just at the risk of repeating myself, my mother, God rest her soul, will be very proud of the fact that my name is now associated with a construct in the new world.
And you're never going to let us forget it.
Yeah, I know. Oh, you're going to hear this forever.
Understand.
It's fabulous. I think this is very straightforward. And Commissioner Braun's point is right. And so is Commissioner Long. Abuse of power, or even basically a crime. It's a crime. Is absolutely going to be covered. So I think this is very straightforward and goes back to my previous comments of sticking with the language.
Does anyone think we should change this at all? And if so, how? Jackie, as we're considering that, and you're in a position, you've been working on this for a long time, is this detailed enough for you? Do you, Maria, if you were out in the field, do you think it's detailed enough for the field? I'm interested in both your thoughts.
Thank you, Madam Chair. If I could just represent what we heard from both work groups in the, as we did these different hearings, that I think the common denominator is that the definitions needed to be specific enough so that the agencies and the officers knew what conduct could be decertifying. And so that was the common theme that we heard throughout. And I would just suggest that you keep that in mind as we go through here regarding specificity. So thank you.
And Jackie, in terms of sexual assault 4, would you say it does meet that, or it does not, based on what you heard from the field?
That is why you guys are the commission.
Say it again. Okay.
I'm sorry, I can't give my
It's fine.
opinion on that. Yeah, thank
I'm
you.
not pushing you, it's just that we don't have the experience you've had. We
Understood.
want to make sure that we are the recipients of your experience. We'll still make our own decisions, trust me.
I
We
will.
want to include
I
it.
can certainly say to this body that the content that we put on this side by side clearly represents what we learned from the 2 work groups specific to the sexual assault definition of sexual assault for this.
Maria, any thoughts on this?
No, again, I think it's clearly defined what sexual assault is.
Is there anything you would add to the sexual assault : that clears up, adds to anything that's written in the body of 827?
I don't believe so, no.
Okay, so where we are now is that we're not touching this one. Okay. Let's see. Kathy, I'm going to ask you again. Now is an hour. If we went to lunch, it's 11:30. Keep going. Okay. So number 5 is demonstrating bias. Please take a moment to read that, as well as on page 5, as well as continued into page 6. Okay. Okay, it turns out, excuse me, everyone, that the pizza will be here at 12, not 11:30. So I'm going to suggest a 5-minute break now, and we'll come back at 11:15, and then we'll go until 12. Thank you. Okay,
I-
then let's take that 5-minute break and go back to that issue. Would all of you spend the next 5 minutes considering whether you wanted to broaden that to include anyone or just members of the public? Thank you.
And he likes your dress, apparently.
Okay, just for the moment, going back to provision 4, sexual assault. If we were to broaden that, my suggestion would be as described in subdivision B of section 832.7, that it would be something like with the addition of or not limited to, and again, it would be attacking this premise of members of the public. Does anyone want to do that? And if so, we can work on the language, or should we just leave it alone? Raise your hand if you want to do that,
I have a suggestion.
please.
I think if you did that.
Commissioner Beal.
And then just added language to also include members of the employing agency.
To also,
To also include members of the employing agency.
my
Because it-
concern with that is still limiting, because people are going to find an exception to that. Well, what if they're not an employee, but they're a volunteer? So I think if we say to anyone,
Or you put, well, just put members of the employing agency. They're members. If you're a volunteer, you're a member. That's what, I'm just saying if you, because that's the carve out.
yeah,
It's any person not employed by the employees, officers employing agency. Everyone else is included. So if we just include the ones that are excluded, I think we're clean.
Right. The definition in 832.7 only applies to a member of the public, which is any person not employed by the officer's employing agency. And so you're absolutely correct. We could add, including individuals not employed by the officer's employing agency and individuals employed by the officer's employing agency. And that way it would include those individuals. That makes
Okay.
sense, if that's what the commission wants.
so Commissioner Buell, you want to,
I'm just
Buell.
wanting to clarify, does that, I mean, from a legal standpoint, does that include volunteers using employed by? I mean,
Yeah.
ethic-
So currently, the law says that member of the public includes any participant in a cadet, explorer, or other youth program affiliated with the agency. So if a volunteer was someone that was a member of the public or a person not employed by the officer's employing agency, I think it clearly would be a volunteer that would be covered under the statute. That's my view.
Let me think about it.
The defining language for me would include employee, because I again, never having read that section, I was a little taken aback that we're not talking about officer to officer that could in fact engage in that, and then that becomes a loophole. So I'm good with it.
So we could either be specific and, to address that concern. So would be subdivision B of subsection 832.7, but not limited to members of the agency, or we could just include everything, but I'd want to make sure that volunteers, any volunteer, because what worries me there is they're specific about the volunteers. They're saying, but law enforcement agencies have volunteers in their victim witness program and a number of other areas, and I don't want to be narrow. So what are you thinking?
We can certainly work on, if the commission's intent is to be inclusive and to include any sexual assault with a volunteer, with a member of the public, with a member of the employing agency, we can come up with that language.
Okay, so what I would do then, if people are interested, is on the whiteboard, I would put after the word sexual assault in parentheses, not limited to, what's the term they're using again?
Members of the public.
Right, not limited to members of the public. That gives staff an opportunity to see how best to phrase that and put that in the, but I still want to make sure that, is there anyone that objects to our making an attempt at broadening that definition?
I don't object to it because I agree that that's necessary. It's just in that 832.7B2, it does say, for purposes of this subparagraph, the propositioning for or commission of any sexual act while on duty is considered a sexual assault. So if we get too narrow, you have two officers that are peers, one asks the other one out, hits on them, whatever, or you have a consensual act that occurs between two peers while on duty, which is certainly out of policy and disciplinary, but does that require them being fired and losing their post certificate? I just feel we might get a little too narrow on that.
Well, an assault does not, in my mind, never includes asking somebody out on a date. I mean, that's that's an abuse of power. So what are you thinking?
Well, that's what I'm thinking, but I'm just saying that the actual language here says propositioning for or commission of any sexual act while on duty.
Correct. This is those of us who've had to do the Senate Bill 1421 work have been flummoxed by some of this language for a while. And you're right. One of the hypotheticals that's thrown about with respect to this definition is, you have some agencies where officers work, remotely, like out of their home or whatever, or even not, even if you have an officer during an 8 or 10-hour shift, goes home and has, on a lunch break, goes home and has a sexual relationship with his or her wife or spouse or significant other. Would that technically fall within the definition of the statute because it's any sexual act while on duty? And you could say that does fall within the legislative language, but then the question as to whether or not there would ever be, because let's face it, there's going to be some element of discretion, right, in terms of what an agency does and then what the division here at Post thinks needs to be moved forward for purposes of decertification. I'd be stunned, frankly, if anybody ever moved forward that instance where a totally voluntary consensual act by, between spouses or significant others. Now that may be engaging in that on duty may be a violation of policy, may be worthy of discipline, but that might not be something that the division or the post itself would ultimately decide would be a sexual act that would be worthy of decertification. But yes, those possibilities are all raised by this language. You're correct.
Madam
Yes,
Chair,
Mr. Yu.
just, let me express the concern, and then if there's a way to cap.
And I need you to move the mic closer or have you guys turn it up. I want to make sure I hear this. Okay.
Sorry, Kathy. The concern I was sharing with my colleagues during the break, actual occurrence were two male officers who were sexually assaulting a female officer, all of the same rank. She did not want to raise the issue because she didn't want to be ostracized and put off into a corner somewhere. And it later came out that this was occurring. And yes, it was a violation of policy for the department, but unfortunately, as it went through the chain, it got killed. And then I found out afterwards, and we ended up terminating all three both the officers for the behavior. I don't want that to be the issue if we're just basing it on 832.7, if now it's not included. And again, I've not read that section. So I don't know if it's covered or not covered, but it just seems to me to leave it to the issue of the public and then have this going on internally. And unfortunately, and forgive me for any of the chiefs here in particular, sometimes these things are ignored or pushed under the rug. And that, for me, is just not something that's acceptable. So that's the concern.
And I completely agree. The nuance of that language was, cops are very literal when it comes to things like this, and they're going to see that and they're going to call it out as being ridiculous and I understand we didn't write the language, we're just stuck with it. But so if we add, there's got to be a way to do it, obviously, because it's something that is not tolerated and somebody should lose their post certificate for, if under the color of authority or abuse of power, or that circumstance where the victim's afraid of retaliation and being ostracized. That's still an abuse of power, but it should be called out under sexual abuse because that's what it is. I just don't know the right words.
Yes.
I'm going to go back to Toby making it clear that we can add, but we can't take away language.
Correct.
So my concern is that their definition of sexual assault was very clear, even though assault is not typically what we would necessarily define as assault. But they're very clear as The propositioning for or commission of any sexual act while on duty is considered sexual assault. If we add the language to include another employee, that's a sexual assault. I completely agree that not appropriate, but is that something you're going to terminate two consenting officers for? So if we add the language of employed by the agency, we can't take this language away. I think we would have to going back to Commissioner Braun's point, is that would be an abuse of power. And absolutely, there is a way to fire and terminate for that offense. I just don't know that adding that language here, because we can't take away from what their definition is. And it's different than my definition, but the language is the language and we are stuck with it, so to speak.
Yes, Commissioner Yule.
Okay, so hypothetically, it's addressed in the department, and maybe the individual, he or she is terminated for the behavior. Do they then get to move to another department with such behavior, or, I mean, how do you stop? I mean, I think the purpose here for decertifying is to weed out
100%.
inappropriate behavior. And so if they're now still able, because of not being decertified, to move around, how do you control that?
I think they still could be decertified under the abuse of power.
But if they were equal, how is that an abuse of power?
Because there is a
Power of authority.
yes, there is the differential of that fear that you're going to be ostracized. That to me is an abuse of office. It is abuse of your power if you are intimidating another officer, because now you're abusing your place within the department and what you can do within the department to their career and with the other officers. Now, maybe other people would not agree with me, and maybe there's a different way to carve it out, because I do think that they should be decertified. Like, to me, there's no place for that. I'm just concerned because we have this definition that we can't take away from. Is there a different way to add that? Because they're saying this is what sexual assault is.
I understand your point, and I also foresee circumstances where people will be exactly of the same level, and something like this could happen. And I could agree with Commissioner Yule. We don't want that person then moving to another law enforcement agency because they lost their job. We don't want them to have their certification. Tricky. Any other thoughts?
Yes, exactly. Under the Donellan Accord, we will leave it alone. I mean, again, I see it as a pretty straightforward question, and that is, do we want to leave it alone, recognizing then that we would not have jurisdiction under this prong, right? Because as we've all pointed out, there may be a particular fact situation where if it's not a sexual assault, perhaps it is an abuse of power, perhaps it is something else. And it may be or it may not be, but the question is, for purposes of this, do we wish to leave the language as the legislature wrote it? Or do we wish to add along the lines of what Commissioner Brazil said, and Commissioner Yule, that a sexual assault is actionable and the commission does have jurisdiction to decertify in the event it involves a member of the public, a member of the employing agency, and we'll come up with the language volunteers or other individuals. And that's really the question.
I think the problem goes back to Commissioner Gordon's comment that sexual assault is not described as any of us would perceive it, but rather as a consensual sexual encounter. So if we add that, then we're saying any consensual sexual encounter between two colleagues is fill in the blank. What do you think about that?
Well, but the problem is that the language of 832.7 already says that. I mean, it already says, for purposes of this subparagraph, the propositioning for or commission of any sexual act while on duty is considered a sexual assault. And I think, the interesting question is, what did the legislature mean in that sentence? And did it literally mean that if you have true consensual sexual acts between consenting individuals on duty, is that intended to be a sexual assault. And remember, this was written under Senate Bill 1421, which was the disclosure, the public records disclosure statute. So the legislature may have had a different intent in Senate Bill 1421. But having said that, in Senate Bill 2, this is the definition they gave us. So again, I mean, I think the other element is I'm less concerned about whether or not this is a regulation that could lead to an individual being decertified for an act that everyone in this room would say should not be subject to decertification, because that is where the discretion comes in. And presumably that's where you would rely on the division not to bring that kind of a case forward, the board not to approve it, and the commission ultimately not to approve.
Would we clean it up if we said sexual assault, any non-consensual sexual assault, using their term, within members of the organization? So if we then added the word non-consensual,
So you're
adding it
so
to
there-
the,
Yeah, so and there you're talking really about the specific language in the subparagraph that talks about the commission of any sexual act on duty, and that for purposes of that
right.
sentence, we could limit it by regulation to refer only to non-consensual.
So non-consensual members. So do you want to fool around with that a little bit and see what? I see the furrowed brow, Commissioner Long.
It's an interesting question, because then I'm wondering if we're removing, right, that's,
Including.
that.
How about if
that's my
it's
concern.
including any non-consensual act, sexual act as defined below to members of the organization? Then we're
We
not
add
taking away.
after, as defined in 832.7B2, also to include non-consensual acts within, I mean, to add to, keep their definition and then add within amongst employees or quid pro quo, power differential, I don't know.
I think you could do that because right now the agency, that's right. The language excludes employees of the agency. So I think we can include employees of the agency under defined circumstances without getting outside of the scope of the legislation. Because we're adding them in is, because right now it excludes them, and we can include certain things that we define if we want to.
So going.
But I'm looking at Toby's going, I don't know,
Yeah,
we're kind of walking the line now.
Well, it's a fine line because of the way that the legislature the legislature described the commission of any sexual act while on duty. So I think there's a question that between officers on duty, it may already be covered if it happens on duty by virtue of that latter definition.
Couldn't you say sexual assault, including non-consensual acts by members of the organization? So we're only adding non-consensual acts to members of the organization.
Sure, you could include that, and I think it's arguably already there, but you could spell it out.
Let's again, I'm going to suggest we give this to the staff, but could you put in the notes the non-consensual act, including, so after sexual assault, including non-consensual acts of sexual assault as defined by 832.7 with members of the organization. Hello? Thoughts?
Would that not be rape?
It's any non-consensual sexual assault as defined by 832.7, and they define any act of sexual contact as sexual assault in 832.7.
But what I'm saying is if we're trying to cover the employee to employee issue,
Right.
the non-consensual sexual acts is rape.
But I think the point, getting to Commissioner Long's point, which I think is probably right, and that is that, the problem is how do we define the legislative intent in that sentence? But, as with all lawyers, you look at it and you look at the plain language first. And the plain language says commission of any sexual act while on duty is considered a sexual assault. And so it seems that the legislature has already has made the decision that if it occurs on duty, that it falls within the definition, whether it's consensual or not. And so the concern would be, by messing with the language, are we removing something? But again,
Yeah.
really it boils down to the question is, the commission's going to have the final say in these cases, right? So if it comes to the commission, should someone lose the ability to be a peace officer in California because they had consensual sexual relations on a break with another employee or a spouse or whatever, that's where the discretion comes in. But I am a little worried about adding language that is arguably subtracting from what the legislature has told us is a mandatory potential subject for disqualification.
Anybody else want to comment on this? Okay, then I think we'll leave it the way it says there. And then what I would just put in it on the notes is members of the organization ? So that in case you all in your infinite wisdom can come up with a way to do this, which doesn't fly in the face of the provision and also adds to it, then you can bring that to us in May. Manny, I'm looking at you and your light is green. Did you want to say something?
Yes, I would. Thank you, Madam Chair. Yeah, just hearing the discussion, I have some concerns that we would be able to, one, do that, and two, to execute. To me, it seems like the penal code is specific to members of the public. And now we're conflating it and trying to make it work for members of the department. And it seems like that will not work. The proposition statement, as mentioned by Commissioner Braun, adds that adds a lot of complexity to putting the two together. I don't think it's necessary. I would leave it as is and go with the Donnellan doctrine. I honestly, that's my opinion. I'd leave it as is. There are other things that hopefully will cover those inappropriate sexual encounters between department personnel. The other thing that I would say is if you all do something like this, that it should be very deliberate, and it should be, but we don't want to be in a position where some officer reads the plain language of what comes out. And then we say, but we don't do that. That's just we don't bring those to the commission. We don't want to have those instances. So it gives me pause to put those two together, because it's very, very clear that 832.7 is meant for members of the public. And now we're trying to put something together that really was never intended to. I don't know what the deliberation was when the bill was going through, but I would hope that this was discussed and that there was some agreement, whoever put it through or in the legislature when they voted on it, to keep it as that. So
Yeah, I think we're all shocked that sexual assault is being defined the way it is. I'm not sure if this is the mechanism to change that or not. So now, having heard from everybody else, raise your hand if you want anything written in the white box on that, if you just want to leave it alone. Okay, and you would like. Okay. Then I think even if we have one person and two people who want the attempt, let's see, maybe you'll come back with something, maybe you'll come back with nothing, but that's why I would put that in parentheses for your consideration.
Madam Chair?
Yes.
I'm sorry if I may. So when we propose the regulation, we could have option A, leave it as is with nothing.
Yes.
And option B, we could try our best to come up with some language to address members of the department. And option C is something else other. We could do that if you would like. Is that doable, Jackie, on our part?
Commissioner Yule, is that okay with you? Yeah, that's okay with me. Thank you. Option A is do nothing. Option B is find some language. And option C is a whole, we don't know about that yet. Got it. Okay. Thank you. Let's begin at least the next one, which is demonstrating bias. And if I could ask you to read what's on page 5 and going into page 6. Okay, just again for discussion purposes, one of the groups suggested adding the words actual or perceived. And I happen to think those are important, having worked on the hate crime legislation, because someone could raise the issue of, well, that's not their race, or that's not their origin. Really, it's what's in the mind of the person demonstrating the bias. It's not what the person actually is. So thoughts about adding the words actual or perceived? Toby,
If I may.
please.
Yeah, one of the things I do in my capacity as a lawyer is employment EEO type cases. And Madam Chair, you're 100% correct. There are a number of instances where bias claims can be made because I acted differently toward you because I perceived you to be in a particular group. And that is impermissible under the federal and state anti-bias laws. And so the question is, does the commission also want to assert jurisdiction over that? So, you know, I might take action against you because you're disabled, or perhaps because I perceive that you were disabled, whether you are or you are not. Or I may take action against you because I perceive that you are of a certain race or ethnic origin when you may not be.
Right. So an example of that might be that they perceive someone as being, I'm making all this up as I go along, they perceive someone as being Jewish. The fact that the person isn't Jewish is irrelevant. And they say to their friends, boy, the Nazis had it right, killing all those Jews. So we know the person is anti-Semitic. And then they behave in a certain way. So we have that evidence in front of us. So the question then, for me, I think it's important to add the words actual or perceived because of exactly the kind of circumstances Toby and I have just mentioned.
Madam Chair, on that,
Yes.
isn't that covered by demonstrating bias? It does, regardless of what the person's characteristics are. If you demonstrate bias, like the first two words, period, it's covered.
Demonstrating bias on the basis of, but basis of is for me, is the actual.
So, but I don't think that has to be, it's what the person committing the act thinks they see in front of them, not what is actually
Correct.
there, from my perspective. So
That's
I
why
think
you'd
you're
have to-
right. I don't want to have to make that argument. I think it's just, you act in that fashion, you fall under this character, or fall into this particular realm, and you absolutely should face decertification. Why we have to now try and prove a negative, I don't really, I'm actually totally supportive. I just don't think we add it. I think it's already there. From my view,
Right.
I think it's already there.
I don't, because I think it's the basis of worries me, because that means it's on the basis of their race, not the basis of their perceived race. I don't know. Others? Toby?
Yes, I tend to agree with you, Madam Chair, and I understand your point, Commissioner Donaldson, 100%. And if that was the case, then yeah, it's not necessary to necessarily add something into the legislation if it's clearly encompassed within the language. This is an issue where I'm going to have to go back and look. I'll take a look, but I believe that the legislature, for example, in other statutes like the FEHA and Title VII and so forth, do specifically include the perceived language. And so the issue would be if we don't include it, then if a case is brought, then it would be defended on the grounds of you can't take action against me because this person was not actually in that protected class, and therefore you have no reason to decertify my employment. Whereas if the commission made it clear that whether it's included or not, the commission's view of an impermissible act that warrants decertification includes acting based on a perception, then if we include that in there, then it removes that argument from an officer trying to challenge a decertification action, if that makes sense.
That's a really good point. So the point is that in every legislation I can think of, every hate crimes legislation, the words actual or perceived are in that. So this would stand out as not having that, which is my concern. It's probably under 422.75 of the penal code that makes an act, a hate crime act, a felony that was a misdemeanor. So my suggestion would be demonstrating bias on the basis of their actual or perceived race, national origin, etc. Is anyone concerned about adding that language? Okay, so let's take a look at that. If you go up to the, and then we have more, but if we go to demonstrating bias and the first sentence, demonstrating bias on the basis of, now we're going to add the following 4 words, basis of their actual or perceived. Should there be there, or should it be a different word? Base of the subject's actual?
I'm just looking, for example, at a government code,
Yeah.
section 12926N, discrimination on the basis of physical disability. Sorry.
Yeah, you could actually turn the mic over.
Sorry.
Or do it
So I
slower.
was just looking at legislative language in another statute, and it says includes a perception that the person has any of those characteristics.
Yeah.
Or that the person is associated with the person who has or is perceived to have any of those characteristics. So we could work on the language if
Okay.
the intent is just to include perception.
Yeah, and I think it would either be there or it would be the subject. So that we know we're clear, we're talking about what was in the mind of the perpetrator versus what the actuality was of the victim. But you guys have never heard me sound like a lawyer as much as you have today.
So Madam Chair and Toby, I have a question. I know that posts in their schools talk about implicit and explicit biases. And I don't know if it's important here to include language, even though I'm mostly on Donnelly Act on this one. If that's going to make a difference in a lot of interpretations as we move forward.
The law has not caught up to the terms implicit bias yet. I think we'd be adding something big time here. Eventually, I think it will. What's your thoughts?
Yeah, I could be wrong because I haven't thought about this. And so I'm now speaking as I'm thinking, which is dangerous. But my understanding of, and Jackie and Maria, please correct me if I'm wrong. I think that from Post's perspective and the perspective of the state law, the implicit bias question is a question of training. And that we're attempting to train officers to understand that they may be acting on the basis of unconscious bias in addition to conscious bias, and to be aware and concerned of that. So it's a training issue. I think the commission, though, can properly consider whatever it thinks is the kind of demonstrated actual or perceived bias that's sufficient for decertification. So your point's a good one, but I'm just not sure, without thinking about it, how we could actually add that to the regulatory language, or whether we should.
I think the way we could do it would be actual or perceived, implicit or explicit. But I do think we're getting into murkier territories with that.
And again, Madam Chair and Toby, I'm not asking to add that language. It really was more just a question because of the training.
I like Toby's analysis that it's a training issue rather than a law. Any other thoughts about that? Okay, let's move into other possibilities in the next 8 minutes here. The social media, anyone think that there should be any inclusion of social media? And of course, that's an on and off duty. Yes, please.
I wouldn't include it, just like you wouldn't exclude it, the language, leave the language open as it is for any sort of demonstration of bias in whatever fashion. I don't think we need to include specific, unless we were to say including but not limited to. But again, it's probably easier just to not single out different forms of where it could come from.
So where we go with this, in my mind, is someone in their off-duty time has a Facebook page that anyone can go to. And in it, they're saying derogatory things during any of the protected classes. Do we think someone should be decertified as a law enforcement officer because on their personal Facebook page? Yes, you know, I'm going, Commissioner Gordon.
I think that regardless of whether I personally think or don't think, there is already a carve out for that because it states
First Amendment.
Well, it states in violation of law or department policy. We all have social media policies that regulate whether you're on or off duty in terms of your social media. That And that policy has already been vetted, quote unquote, in relation to an officer's rights, according to the Constitution of the First Amendment. So I would hate to get more in the weeds than it already is. I think there already is that for that type of, if it's a pattern and egregious behavior, I think we all have department policies that would allow for that. And I think the way this is already written would allow for the decertification if it was that type of behavior.
Okay, any other thoughts on that one? What about just on and off duty bias? So someone in off duty acts in a racist, sexist, whatever manner, walking down State Street, whatever it is. Are we going to hold all law enforcement officers to the standard that they can't engage in off-duty bias?
If I may.
Please.
So the legislation does already have the references we pointed out to the First Amendment carve out. And not to get too law geeky on it. And to be honest with you, it's been years since I've done a deep dive into this. So I can just give you my sort of general recollection or understanding of that area. And I may get some of it wrong, but the general idea is that there's already a well-established body of law under the United States Constitution, the federal Constitution, and state law with respect to the First Amendment rights of a public employee. And the general idea, and hopefully I'm going to say this right, is that when an individual is speaking and that speech involves the employment, involves their public position, then there's no First Amendment carve out that you can regulate that conduct. So the question is, if it's a public employee and the employee is not acting within the scope of their duty, it's not within the core function of their duty, so they're speaking as a private citizen, then the question is, then there's kind of a multi-factor or balancing test. If you're acting as a private citizen and you are speaking on something that's a matter of public concern or some public thing that's out in the media and that people are talking about, but it's outside of your job duties, then there is a First Amendment defense, but I think that's subject to a balancing test. So kind of the bottom line is there's a lot of law out there already that addresses the question of whether or not you can restrict or punish a public employee for engaging in off-duty speech.
And I know that I've punished some of my employees for investigators for conduct unbecoming. And I think there is an area for conduct unbecoming. So I guess we're not trying to redefine that, but we certainly, this raises it to a level of them being decertified. So does anyone want to add anything about off-duty behavior to this?
I'm going to go back to my original point. I think it's already covered within departmental policy and wouldn't want to expand anything that's in here because we may actually limit ourselves.
Okay.
By trying to do good, we may actually limit ourselves with this. I think we all have department policies that are very extensive in this area and that account for all the different laws. Because, the languages here is a violation of law or department policy. And even it goes so far as to say inconsistent with a peace officer's obligation.
Let me bring up one last issue before we break to lunch. How about the duty to report? So we have a whole bunch of demonstrating biases, and so this is now pointing to the person who's engaging in the act. So they're demonstrating bias on the basis of da 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 da. Nowhere in there do we suggest that a fellow law enforcement officer observing this has any duty to report in this provision. We may have that other places, but not here. Does anyone think that's an important thing to add here?
But I go back to department policy. We all have department policy that spells out what someone is obligated as, what an officer, what conduct they are obligated to report of a fellow officer. And I do also think that's part of that training issue we talked about, because I just had the pleasure of taking post new bias training. That is part of that. It's part of that training mechanism. But I think it also once again goes back to department policy. I think as it's written, it does not prevent us from decertifying an officer for failure to report. So that would just be where I go with this, is that department policy piece. There's actually a lot of quote unquote leniency within that for us as a commission to take appropriate action on those type of
So you would say
cases.
no need to add duty to report.
Because I think it's part of that department policy.
But you do know that some departments don't have policies like that.
Yeah,
They're not all great.
If
Most of them
we
do.
added a duty to report there, that could also put in a precarious position, the person who's the victim of it, say,
Yep.
that you're Jewish and someone says something pro-Nazi to you, then you have an obligation to report it, but then you're also ratting out that it puts you in a spot. So if we added that, I think it could get murky.
Madam Chair, also, and I understand where you're coming from, because some of these actually, duty to report, it may not be something that we do certify as a post commission. However, I'm going to get back to what's the legislative intent. They wrote this. I do believe that, it could change. It's a living document. Legislation may say, okay, we didn't take it to a high enough level, and now we're going to add this category. I just think that we should see how this goes, because there's a lot here that we're digesting, a lot put on post to get this implemented by next year. So I do understand what you're saying, that some of these things aren't included. It would never come to the commission. But I think we should just start with stay within the Donnelly doctrine. So.
Manny, what are your thoughts about duty to report being included?
I think it's a very sticky issue. I think was mentioned by Commissioner Braun. I personally would just leave it as is.
Is there anybody that wants to add something about duty to report in this provision? Okay, we're back to the pizza and the Donnelly. So in that case, the only thing we've added to this is the actual or perceived.
Madam Chair, if I may add, I think I should have said one other thing too.
I think you're speaking too softly.
Okay, I'm sorry. To me, it's clear that this is targeted towards the individual, not to everybody else. Demonstrating bias is targeted towards that person who makes those comments. And I think we would be expanding it significantly to anybody who witnesses it, hears it. I wouldn't do it, but that's it.
And certainly when we get to number 9, the failure to intercede is certainly another avenue. We can bring this up again, just for the fun of it. Okay, it is
Madam Chair,
yes.
has there been any contemplation of an audit over the next, 3-4 years out, to go back and take a look at what is being missed, so that you can then revisit some of this language to make sure you're capturing those things that have dropped through the cracks?
I've never heard of an audit at all, but I love the idea of it. I think the audit is in due process would be cases coming to court and people arguing that. That's one audit. Another is us hearing about it from the field and us deciding we want to change it. But there's no official audit that I'm aware of. Toby?
No, I'm not aware of it either. I actually had thought that sort of as this shakes out, and Jackie and Maria, you and your teams have been working on this much more than I have, but I think that it just strikes me that factually what may happen is we're going to have all of these cases brought in to the division, and then you folks are going to have to be sorting that out. And it just may happen that you run across some cases where you look at it and go, you know what, everybody's pretty much in agreement that that's a decertification case, but we can't rope it within one of the 9 particular areas. And the question, I guess, for Manny and for staff is, when that happens, how does the commission want, that to be periodically raised in terms of whether or not there's reason or grounds for an amendment or an addition or some other grounds for decertification.
Another possibility might be to put something on our website, as it relates to 2. If people want to make some kind of comment, and I'm making this up as I go along too, to make sure that we're in touch with the field on this too. And that's something else we can think about. Are we getting enough information to see what's working, not working, some glaring mistakes in this? So at the formal audit, there isn't one, but informally, we can think about how we want to get information from the field and from the communities.
Madam Chair?
Yes.
Yeah, on that, I actually think that's a very smart idea. I think it as an organization, we're going to have some introspection moving forward with this to see how this is working. It's just such a large and broad project that I'd say a year in, 2 years in, and regardless of any other mandate outside, such as an audit, I think us as commissioners would actually seek input from the staff, you know, pros and cons. What do you see? Are there legislative changes? Are there administrative changes that we can work on to improve this process? Even today, you're seeing as it shakes out how convoluted and complex this is going to be. And I think a constant effort at reevaluating where we're at as an organization and with the implementation of SB2 is going to be a necessity moving forward.
I agree. Okay.
Along the lines of what Commissioner Ewell brought up, and I don't know how we captured that, which we won't know, is there any thought about how do we find out or audit things that aren't being brought, things that actually happened in an agency that weren't reported up? Is there going to be an audit process for that? And that's probably more of a legislative fix, because I don't know if there are repercussions for an agency that doesn't report things that ought to be reported.
Well, there certainly are laws about not reporting when it comes to, for instance, if a child is some kind of act of alleged child abuse and it goes to a staff member at the school and the school doesn't report. I've prosecuted principals and assistant principals for not making the report. So we know that there is a legal means to do something like that. That's biting off a way bigger apple than we've been asked to do today. But I think, you know, we should think about agendizing this. Maybe that's the best way to do it for January 2024, and finding ways that we can have anonymous statements made from people, so that if and start seeing the problems that this exists. Maybe there's a way to do that on our website. I don't know, but I think we should think about it. Yes, Mamie.
Defer to Commissioner Ford.
And just one other point on that, because I think it's very, very valid, is we could look at, one of the things we may be able to look at is what public complaints come in, because there is a provision for this that allows the public to make complaints directly with Post.
Yes.
And that may be in the short term, before there's a lot of data, kind of give us a snapshot of what's coming in, because I think you'll get a lot better picture of what they're not happy with agencies investigating. When individuals start realizing, oh, we have this other avenue and we're not happy with what's being reported, maybe we'll get a kind of a snapshot. So it might be helpful as those come in ahead of time. Staff thinks about how they can categorize and really keep track of those in terms of the data points and the information, not just in terms of the investigation.
Madam Chair, if I may.
Please.
So I think one of the positive things, the beauty of the way the bill is written, this is not a one and done. This is as we were referring to it, as a living document, like all of our regulations, you know, that are not related to SB2. You see us coming to the commission with tweaks constantly. Just discussing it during one of the breaks, you know, and I made a comment, we're going to be right back here in 18 to 24 months doing exactly the same thing, because we're going to find that it's not 100% perfect, or things are going to need to change. I think we'll do our best to capture some of that and make our recommendations. And hopefully you all will have some of that also from members of the public or members of the department. But that's one of the positives, is it can be changed. It will be changed. There's no question about it. Obviously it has to go through the regulatory process, but I suspect very, very confidently that we're going to be right back here at some point in time. The second question, or the second issue, that we've had a lot of internal discussion about enforcement. You know, how do you enforce all of this? Because we know, and we had discussion just yesterday with one of the commissioners, there are going to be departments, or there's going to be instances where a box is checked. that it's not the right box, right? So excessive use of force, as we talked about yesterday, there may be something that meets that criteria that's reportable, but they're going to look at it as bad tactics and we're not reporting at the post. How does the commission deal with that? Does the commission deal with that? Does that need to come to the commission? Obviously they're in violation of the penal code, but what role do you all play in that? And what role do we play? That is a very open discussion. We've had a lot of discussion about that and we've just kind of left it. But it will likely happen.
Anything else before pizza? Okay, it's 12:10. Let's take a half hour. And so we'll start again at 1. And I believe we actually have a special room.
Yeah, we have training room D, which we are calling the dining hall today. We didn't know how many people were gonna be here, so we wanted to give you guys a little bit of space so that you can have a lunch away.